Present.
Wilson,
Present.
Broca,
Present.
Faith.
I am here.
Madam Chair, we have a full quorum this.
That is a wonderful thing.
And Madam Chair, we have no postponements or withdrawals this morning.
Really? Okay.
Excuse me, Madam Chair, I'll just take this moment to mention that we have 3 council members present. The order that they arrived is as follows: Councilman Slight entered first, followed by Councilwoman Gray, and lastly, Councilman Hart.
Okay. Thank you for that. All right, so Ms. Holzer, with that in mind, we will move to calendar number 24-039. As a courtesy to the council members, when they are present, we take their cases at the top of the agenda in the order in which they arrive. Thank you very much.
Sounds good. Thank you, Madam Chair. All right, scrolling down my agenda. Our first case is calendar number 24-039. This is at 14901 Triscuit Road. Patricia Mahoney, owner, proposes to erect a front yard 2-story frame library addition and 2-story rear breezeway with 20-foot by 20-foot garage attached to an existing single-family residence in a B1 2-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 2. And with that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holzer.
Thank you. I will swear in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? You'll raise your right hand, reply with I do, state your name, spell your name, and your address. We'll start with you.
I do. Charles Slife, S-L-I-F-E, 601 Lakeside Avenue.
Okay, thank you.
I do. Neil Money, M-O-H-N-E-Y. The address is 16517 Edgecliff Avenue, Cleveland 44111.
Thank you.
Patricia Money, 16800 Riverdale,
Okay, and I'll just have you spell your name, please.
M-O-H-N-E-Y.
Perfect, thank you. Is there anyone online who wishes to speak in this matter?
Yes, my name is Ethan Poor, owner of the adjacent property, 14805 Caldwell Avenue. Just want to be present in the hearing and, give my final thoughts.
Okay, and do you swear or affirm that the testimony you will give is the whole truth and nothing but the truth?
I do.
Okay, thank you. Anyone else online wishing to speak in this matter? All right, hearing none, back to you, Madam Chair.
Ms. Wilson, would you have him spell his name?
Oh, yes. Mr. Ethan Poor, can you spell your name for the record, please?
Yes, ETHANPOOR.
Perfect, thank you.
Thank you.
Back to you again, Madam Chair.
Thank you so much. Just so everyone knows, our court reporter works remotely. So we ask that is part of the reason why we ask that you spell your name and that we ask that you are clear and concise with your statements so that she can record them. All right, we'll go to the history of the property.
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 1945, it was changed to 2-family residential. In our Records Administration Office, we found that in 1937, a permit was issued to erect a new dwelling and private garage. There were no variances on file for this address and nothing of note in the more recent history. Thank you.
What year was that constructed again?
1937.
Really? Oh. Cool. Legal standard, please.
Madam Chair, members of the board, appellant is requesting area variances from the garage door and required front yard setback requirements of zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by the land and buildings of the same district, will deprive the appellant of substantial property rights, and the granted variances will not be contrary to the purpose and intent of the zoning code. And then there's a note that section 329.04C limits the board's ability to grant front yard setback variances unless certain circumstances apply.
We haven't had that one for a little bit, so.
That's why I'm here.
Thank you, Mr. Slade. All right, who's going to be the spokesperson?
I am.
All right, I figured as much. And I take it you're related?
It's my mom.
I suppose that. All right, good for you. All right, You have two variances that are on the request list, so tell us, speak to those and tell us what you want to do.
Excuse me, Madam Chair, sorry to cut you off there. Shannon Leonard has her hand raised in relation to number 2 on the agenda here. I think she could speak to the setback in front yard.
All right, Ms. Leonard, thank you for raising your hand. Go ahead and make your comment.
Good morning, Madam Chair. Shannon Leonard, Interim Chief Zoning Administrator. The applicant does not need a front yard setback. After reviewing their survey with our survey department and the plans examiner, the Triscuit Avenue street is actually 80 feet wide, and so they no longer need that front yard setback. In addition, they should not change their address because then they would make the house completely unbiddable. So if they leave the address as is, they do not need number 2 on the variance request list for the front yard setback. They would only need the garage variances.
That's excellent. Thank you, Ms. Leonard. All right, does that help you out?
That sounds great.
Yeah, we always like when that happens. The front yard setbacks are always an issue for us. All right, go ahead then.
And then there is a history of the photographs. What we plan on doing, this was the prior years, up to 2011, we saw that that was the porch, but now that's not an issue, I guess, because of this front yard setback. We plan on putting in a library where that porch is, and then another room above that one to act as a bedroom/office on that side of the property. So if that's not an issue anymore, then I think that part is moot. Okay.
Correct.
Okay.
Right.
All right, then I guess we move on to the garage.
Correct.
Okay,
Mhm.
and the garage that we're asking currently sits at, the setback is 18 feet. And we're requesting 16 foot 9 inches. And then I can actually can see on the survey. Get the survey. That's from it's the architect's rendering. It's under the
Mhm.
survey should be in there. There we are. And if you want to back up a page, you can see the what we're actually looking at. So the new addition to the right is the Triscuit side, which we want to build on the existing porch. So that's on the left side where the garage is. That's the breezeway space above it, and then the Duke car garage. And that garage, the front of the garage is 18 feet from the setback needs to be 18 feet, and we're requesting 16 foot 9 inches. And we can, the garage is set back 3 feet from the property line, and we can go to the survey. You can see that it's there. If necessary, we can move the garage farther.
Getting started on it like he wants to.
Great, thank you so much for that statement. Do we have correspondence to read in?
We do
Ms.
have
Cookwell?
2 emails of support, one from Jan Wiley. She stated that her name is Jan Wiley. She lives at 14905 Triscuit Road, has so for the past 24 years. I live next door to the property. The Mahonies purchased the house after a previous owner passed away. They have been renovating the house. They've shown me numerous times the progress and plans for changes. The changes will improve property values in the neighborhood, and she is in favor of the variances. And there's another email from Mr. Otto and Dr. Mahdi Home. They wholeheartedly support the Moni family's proposal to remodel the project, as it will enhance property values, improve the aesthetic, improve streetscape. It will improve investment appreciation, as well as preserve the community character. And they live at 14918 Triscuit. And those are the 2 support emails that we received.
Okay, so that's it then, huh?
Yes.
Super.
There were 3 more support letters that they copied us on, so if you want to.
Oh, you have more? You can give those to Ms. Cooper.
I know there was one from a Marlene Zapp. I know she had emailed me too.
Okay, great. We'll just get those noted into the record.
And then we had these up on the street and.
Okay. There are two additional ones, Madam Chair. And Roberto at 14900 Trisket Road. So she states, please allow Patricia Amoni to make the changes she wants. There are at least 3 non-owner occupied homes in the neighborhood that could use some attention. It would be a welcome change for someone to improve their property. And one from Marlene Zepkin at 1471 Caldwell Avenue. The residents, and just a few houses down from the residents in question, she would like to applaud Neil Money on beautiful additions and improvements proposed to this longtime neglected residents. Very much in favor of improved rendering and details provided. Believes this submission not only blends well with existing neighborhood properties, but will be a huge enhancement to the corner of Trisket and Caldwell. Since the title transfer, he and his family members have cleaned up the property significantly, removed all debris, maintained the ground, etc., and established relationships with the neighbors, keeping them informed of its plans. They will be a welcome family. It hopes that this project will not be the last to inspire others, new and old neighbors, to improve their properties. And again, that's from Marlene Zepkin at 1471 Caldwell Avenue. The other 3 that were submitted by the applicant for the ones that were received.
Super, thank you. All right, Ms. Holster, I didn't ask if you had any questions, do you?
No questions from me, Madam Chair.
Super, thank you. All right, I just had one question, really not zoning related, but I'm wondering why you specified W trusses for the garage.
I believe that was the architects.
Yeah, do you know why?
Mhm.
Okay, all right. Would not have been my choice, so you just might want to revisit that. That's not what we're here for, but it impedes storage, but may be necessary for load. Okay, anything else, anyone?
No, just it's an attractive design, how you balance the additions on both sides. Thank you.
Yeah, we have a great architect and he put all my ideas on paper. And the reason we did that, the smaller addition that's on the Trisket side with the gambrel roof was again because we were facing the Trisket side, so we didn't want to impede too much on that end of the house. So we kept the scale proportionate to the house and the neighbor.
No, I really liked the plans. I thought that was, the addition was very sensitive to the architect. So,
Thank you.
yeah. All right, if there's no further comments or questions, I'll entertain a motion.
Excuse me, Madam Chair, City
City planning.
Yes, city planning, chime in.
Cedar Bay City Planning, we recommend approval for variance for the attached garage. There isn't much room to move the garage any further back to the property line, south of them. So, these are minor variances that they're requesting, so we recommend approval.
Thank you, Mr. Bain. Thanks for raising your hand to chime in. All right. Anything else, anyone?
No, Madam Chair, I move approval of calendar 24-039 after hearing testimony from the owners and support from adjacent neighbors and Councilman Slife. I offer and move that we approve the variances regarding the attached garage.
Great, thank you. Second, please.
Madam Chair, I second.
Ms. Roca seconds. Ms. Kukla, call the vote, please.
Ms. Holter,
Yes.
Ms. Wilson,
Yes.
Ms. Roca,
Yes.
Ms. Brown,
Yes.
Ms. Bates.
Yes.
Calendar number 24-039 is granted. To be ratified next week, we will send you a letter, but please feel free to contact our office next Wednesday for further instructions.
Great, thank you so much.
Thank you. Good luck with your project.
Have a good day.
You too.
Thanks for stopping by, Councilman.
See you.
All right. We had Councilwoman Gray next.
All right.
So that takes us to calendar 24-015.
Sounds good. Our next case is calendar number 24-015. This is at 2923 East 125th Street. Turning Points Behavioral Health owner proposes to establish use as a residential facility for 6 occupants in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 2, with some notes. First note is that this board denied a request for a variance in calendar number 23-58 to establish use as a residential facility for 8 people. This case may be considered a quote-unquote refiling, and the board may be limited in its ability to grant a variance unless the appellant can show significant change to conditions or the plan. Additionally, this case was postponed from February 26, 2024. The postponement was made at the request of the appellant due to a scheduling conflict. And with that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holzer. I will swear in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the truth, nothing but the truth? Please raise your right hand. State I do, spell your name, state your name and your address. I'll start with you, Council.
I do. Councilwoman Deborah Gray, DeBorahGray, 601 Lakeside Avenue.
Thank you.
I do. Lois Henry, 2919 East 125, LOIS, Henry, HENRY.
Thank you.
Do Shelda Brantley, SHELDA BRANTLEY, 2923 East 124th Street.
Thank you.
I do. George RG, ARGIE. I'm an attorney. My address is 6449 Wilson Mills, Mayfield Village, 44143.
Thank you.
Thanks for shutting the door for us, sir.
You're welcome.
And again, if you'd spell your last name again for me.
ARGIE.
IE. Okay, super.
All right. Is there anyone online wishing to speak in this matter? All right. Hearing none, back to you, Madam Chair.
Okay, Ms. Kukla, you want to bring us up to speed on this?
Sure, Madam Chair, what stated this case was denied. There was a similar case denied in July of 2023, and that's calendar number 23-058. Same owner proposed to establish use as a residential facility for 8 occupants. I'll read in the testimony from the last hearing. The board reviewed photos and site plans showing the dimensions and number of beds. The appellant stated she is currently operating a home for 5 residents at this location, and due to such a large demand, she proposed to expand the number to 8. She stated that residents will be self-sufficient and seniors ages 50 to 80. Some will have mental health issues. Staff will be on site from 9 a.m. to 5 p.m. and then midnight to 8 a.m. Meals will be provided and curfew at 10 p.m. Ms. Henry and adjacent neighbors stated that she has had some negative interactions with the residents. She claims that the tenants are left to do as they please. Ms. Henry stated that she has seen residents urinate off the porch. A letter of opposition was submitted and read into the record. Councilmember Deborah Gray stated that she does not believe that the facility will work since the residents will be sharing rooms with strangers, and that she supports the neighbors regarding their concerns about expanding the number of units. Chief City Planner Maurice Rowland stated that the city is concerned with allowing an oversaturation of these types of uses, and they echoed the opposition stated by the neighbors. And this therefore was denied, and the effective date was July 24th, 2023. So we received documentation from the applicant. You have received them in your Dropbox link. The appellant's attorney is here, I believe, to expand further on the request today.
Okay. We'll go to legal statement.
Madam Chair, members of the board, appellant is requesting a use variance and an area variance from the minimum distance requirements of the zoning code. This case is a refiling of an appeal that the board decided and denied in 2023. According to Rule 8 of the Board of Zoning Appeals Rules and Regulations, the board must dismiss the refiling of the appeal as res judicata unless the appellant can show a basis that would prevent the application of res judicata, which may include changed circumstances, substantial and relevant evidence that was not available at the hearing of the prior appeal, or that the application of res judicata will create manifest injustice. Additionally, the board may dismiss the appeal if the applicant fails to submit documentation demonstrating a basis that prevents the application of res judicata within 30 days of the date when the secretary mailed the notice. The date, I believe in this case, was January 17th, 2024. If this hurdle is cleared, to obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land buildings in the same district, will deprive the appellant of substantial property rights, and that granting variance will not be contrary to the purpose and intent of the zoning.
Great, thank you. All right. Are you addressing the res judicata issue? Is that, or?
Yeah, if I may.
Yes.
I heard early on that while this is an amended application, that we were seeking a approval for a 6 person unit. It's actually 5. So I'm not sure where the 6 came from, but the last time around, it was for 8 residents, and now we are seeking approval for 5
For
residents.
5, not 6.
Not 6.
So
Okay.
you do you currently have 5 when?
No, yes, I did. I'm sorry. I didn't mean to
Yeah,
interrupt.
Liz, excuse me, the secretary, stated in her recitation of history that there are 5 occupants at the property currently. Is that correct?
That's not correct.
Okay. What is the correct?
I read that prior. I was not at the earlier hearing in this matter, and
Right.
I asked my client Sheldon Brantley, who's seated to my left here, whether there were 5 residents occupying the premises, and that's not the case. I'm not sure exactly where that came from, but my understanding is, and she can address it, there is just one person who is a tenant that is occupying the premises, and the reason for that is, she didn't want to leave it vacant and out of concern that there could be vandalism or something like that, or an issue with insurance for the property. So there are not 5 residents there, but 1 tenant.
Thank you for clarifying.
Right.
Madam Chair, for the record,
Yes.
we take our notes from the testimony that's given at the hearing. We do listen to the minutes as well when we're writing the resolution. So the notes are based on what I heard in the testimony.
Okay.
Where there could be a little confusion is back in 2014 to 2018, the property was utilized for 5 residents. So I don't know if that's maybe where the confusion lies. Is that correct?
How long has this one single tenant been in the habitating the property?
About 8 months.
8 months. Go ahead, ma'am.
That's not correct. Just within the last 3 months, it was more than 1 person in the house.
Remind me where you're living in relation to
Next
this?
door.
Next door to which side? As we're facing it,
To the left.
to the left. Okay.
Madam Chair,
Yes, Ms. Brown.
I'd like to know when there were 5 residents for the group home from 2014 to 2018, if Ms. Brantley owned the building or did someone
Good
else?
question.
Charles, you want to address that? How long have you been the owner of this particular property?
Since 2013.
Thank you.
And who owned it prior to that?
My daughters.
Okay. And there was a period of time where you did operate it with 5 residents, is that correct? Approximately, when was that, 2014 to 2018?
Correct.
Okay, and why did you cease operating that with 5 residents?
Because my father died, and shortly after that, my oldest sister died, and so I surrendered my license because it was too overwhelming for me at the time.
And one of your neighbors had just suggested that there was more than one tenant residing at this property in a more recent period of time. Do you know anything about that?
No, there's just been the one resident that I have there. The state just came out and surveyed this property, and they just gave me the approval. So there's nobody else there because I'm not allowed to have anybody else there. So there's only one tenant there as of right now.
And if the tenant had some guest or somebody staying there for a brief period of time, would you necessarily be aware of that?
I would be aware of that.
You would be aware of that? Okay. Do you have a written lease agreement for the property?
Yes,
Okay, and the tenant's name?
David Minnick.
Do you have the date for when the state was out to survey the property?
The state was out to survey the property in September of 23.
And they gave you the approval for how many residents?
He gave me the approval for 8 residents.
While we're on the topic, can you tell the panel a little bit about your business close to home, adult family home LLC?
Yes, I've been in business for 18 years. I operate several group home facilities. I haven't received any citations for any of my facilities. I haven't received any correction for any of my facilities. The state just came out and removed every last one of my facilities, and I had 0 corrections or any repairs, everything passed.
I'm sorry, go ahead.
But I provide service to people with mental disabilities. I provide the food, I furnish the facilities, I provide food, snacks, utilities, laundry, everything that they need is provided there at the facility.
Why do you think this is important, what you provide for the community?
This is important because this allows seniors in this particular location to not have to live into a nursing home or not to be able to maintain their independence and live comfortably in the neighborhood.
Have you ever had a license suspended or revoked?
I've never had my license in 18 years suspended or revoked.
Excuse me. Yes, ma'am.
This is the issue I'm having. She said wasn't anyone else in the house. So why am I seeing young men running across my front yard, going back into her house within the last 3 months? And my neighborhood is a mature neighborhood, and I'm a precinct committee person. When they see strange people, they call me, who is it? We don't know who it is. And it's very disturbing to have people coming in and out. We don't know who they are, where they come from. So everybody is afraid on the street because of this. And someone was living. How do I know? Because when I walk down my steps, the bedroom that they were sleeping in is right here. So I couldn't help but see the peoples in the bedroom. And that was less than 3 months ago.
All right. Thank you. All right. So, so it is your intent now to ask, I mean, you're asking for just 5 people, not 8.
Correct.
So that should fulfill, you're asking for that to be the significant change
Right, in circumstances.
for us to
yes.
proceed. All right. Ms. Kukla, you read the testimony from previous as to the population, the ages, the meals, the medication service, all of that. Is all of that remaining the same? Okay. Mr. Bay, do we have the map showing the?
While he's getting the map, I didn't quite catch the hours for staff. Can you
Sure, want to
ask
reiterate that for
for
us?
that to be stated again?
And I might add that the the neighbor that has these concerns with one tenant in there and whatever's going on in that area. Again, I don't know if it's directly attributable to the tenant that's there now, but certainly if this was approved for 5 residents and we would have people on staff, I think that could resolve that problem or issue or concern that she has, because there will be oversight versus a tenant that pays their monthly rent and you get a call if repairs need to be made or something like that. So just wanted to make that comment while I was listening to what she had to say.
Thank
But
you.
If you can tell about the staffing, the hours and that sort of thing.
The staffing hours will be from 9 a.m. to 5 p.m. And then there will be overnight staff there from 11 p.m. to 7 a.m.
So from 5 to 11, is there staff or no?
No.
Okay.
Is it 11 p.m. to 7 a.m.?
Yes.
Huh. And that's the normal operations for all of your homes, the timing?
No. It depends on the level of care for each resident. I have one facility that's 24 hours, so that 24 hours is staffed for 24 hours. In this particular location, it won't require that.
Okay, so who is the target audience at this, that you are planning for this home?
Seniors.
Independent seniors, will they cook their own dinner? They eat before 5? I'm not getting a picture of this. You really have to share a little more.
Okay, so the seniors' ages will range from 50 to 80. Meals will be prepared on site by the staff. Laundry will be done by the staff. Medication, if there's any requirement, will be done by the staff. Everything
Okay.
will be done by the staff.
And are these seniors who will likely need transportation, have their own cars?
They'll need transportation.
Do you provide transportation or other service providers?
Yes, I'll provide transportation as well as their insurances. So some of the insurances, as long as you call within 24 to 48 hours, they'll provide transportation if needed.
Thank you.
All right. Ms. Wilson, any questions?
So for me, the changed circumstances is just still not clear. It's my understanding that the first application was for 5. And
Was
now they're
for
back
8.
for 5. So the first is for 8.
The first was for 8.
Okay,
Right.
got it. Okay, that clarifies.
So
it for me. Thank
that,
you.
now we're down to 5.
Okay,
We thought it was 6, but it is 5, so that's
okay,
what they're seeking. Does that fulfill your,
that does.
okay, great.
Thank you.
Ms. Roca?
I had pretty much the same question. So the change circumstances, the reduction in occupants, and the new evidence that you're submitting to the board, which is another element of the res judicata standard, is that you're just gonna have 5 instead of 8.
Right, and we also have submitted some, I believe it was Miss Henry, if I caught her name correctly. She wrote an email the last time, which was not here, and it's quite honestly a rather scathing email about my client as an operator, as someone that maintains properties, and there was a reference to some litigation where she was supposedly cheating some people. We would like the opportunity to address that. We've submitted some brochures for you to see some of the properties, including this one.
Those were in our packet, but
Okay.
you may touch on that point.
Right.
So the board should have already reviewed all of that,
Okay, all right.
since it was in the packet.
If they had any questions, Sheldon could address the improvements that have been made to the property. Since she was here last time, the property at 125 that brings us here today, she's put new windows in, is that correct? So, as she said, she's been doing this for 18 years. She reinvests in properties. We provided examples of a couple other properties that she has here for your consideration to show you how she does in fact maintain properties. It was raised that she was behind in real estate taxes. She did at one point fall behind for a number of reasons, but set up a payment plan. She's paid those, kept current, and paid back the real estate taxes on the various properties. And there's one more, I think it's this property. And how many more payments do you
I
have?
have 4 more payments.
Okay, and you remain current with the taxes?
Yes, everything is current.
And if I could also address a lawsuit that was brought up, again, kind of attacking her business. If you could tell the panel first about the 3 people that you hired and why you hired them to work at one of your facilities.
Well, I hired 3 people initially. I went down to the shelter because I wanted to offer them a second chance. And because of the situations that they were in, it led them to the shelter. I thought it'd be a good way to reinvest in the community. So I went to the shelter. I got 3 people out of the shelter. I provided them with a compensation package, would allow them to live on the facility, take care of my houses for me. I provided food for them, shelter with them, and I gave them a package. As a result of that, they turned around and sued me because they said that they were wanting overtime. And so that is what led me to the lawsuit. So they all got together, and I just tried to extend my hand and show them some love, so to speak, and then they turned around and sued.
And if I could address the lawsuit, Shell had hired a lawyer to handle the matter for her, who clearly was not experienced in handling these matters. She did not comply with certain discovery requests, which ultimately ended up in the court, entering sanctions that Shelda could not contest the liability under the Fair Labor Standards Act. Shelda was not aware that this was even going on. Her lawyer was not keeping her informed. The plaintiffs then filed a motion for summary judgment. Shelda was not aware of that. They submitted affidavits in support of their wage loss claim. Shelda was not aware of that. Her lawyer never reached out to her to refute any of the evidence that they had submitted. In fact, not only that, the lawyer replied without any affidavits. There was a judgment entered in the amount of $325,000. Shelda's lawyer did not inform her of that. She learned months afterwards that a judgment had been entered. She then retained me. We tried to get the judgment vacated. It's very difficult when your lawyer doesn't do what they're supposed to do to get a judgment vacated. We ended up suing her lawyer. We ended up entering into a settlement agreement. Even she was stuck with the $325,000 judgment, although she believed if they were entitled to anything, it was nowhere near that. We set up a payment plan to pay them. In the meantime, I had sued her lawyer for malpractice. And just in the last month and a half or so, we got it resolved. Everyone that was part of that lawsuit was made full. They were paid in full. And the case has been resolved, the judgment dismissed. But I know that was being used against her somehow, but she was not remiss in any way. I'm not even sure if they were entitled to overtime compensation, but they may have been, but the way the case was handled, it became indefensible. It was never refuted. So I just want you to know that Shelda stepped forward and took care of those issues.
You were not present when she was before us previously.
I was not.
Right. And there was some significant pushback from the neighbors in that particular testimony. So I was coming to you next.
What about city planning and the proximity? Did they talk about that?
Yeah, Miss Gray has her hand up, so
Oh,
I'm
I'm
gonna let
sorry. Thank you.
her speak, and then we'll let Mr. Bay chime in.
Understood. Thank
Yeah,
you.
sure, thank you.
Yes, how everybody doing this morning? I just wanted to just reach out for the residents and on that street. Could you pull back up the signatures that was on there? You had signatures from the residents.
Mr. Bay is pulling that up for us.
I just want to see, were those signatures from last year or was those signatures from this time around?
This time.
Okay, because Miss, how you pronounce your last name?
Brantley.
Miss Brantley has not reached back out to me since last year, July. Until I got this notice this time around to come
Okay.
here. We have not had any conversation
All right.
for her reducing her clients from 8 to 5. So when I got this notice, Ms. Lois Henry called me just before I got this,
Mhm.
and I wasn't aware that we were coming back in. So due to what she have done, we have not had conversation for her to tell me that she's reducing it from 8 to 5, and she could at least had a conversation with me. We could have went back on the street. I could have went on the street, had time enough to go back and talk to the residents, which I didn't have that time until Miss Henry called me. So all this new to me when I got this and Miss Henry called. So from last year, July, I don't know why Miss Bradley didn't call back to say, Councilwoman Gray, I'm reducing the clients from 8 to 5, and could I have another conversation with you? Could I come to your meeting? Could I at least, Bill, could I at least walk with you in the neighborhood, even though I'm going back to get signatures? Make make appearance to what more of the change that you have planned to do to make it good for you. But in the sense of some of the residents still feel uncomfortable of the situation, not because she's reducing it from 8 to 5. The residents just feel uncomfortable of the group home alone of the clients that she have. That's their personal right because they've been homeowners for 30, 40, 50, 60 years on the street. That needs to be taken in consideration. So I'm just saying that we're here today with no conversation from Ms. Bradley to the council person to let me know of any change that she had during this period. So I just still have to support the residents, how they feel in the community. And I had a chance to go back behind Ms. Bradley to go back and talk to the resident on the list that she went and and communicated with. And I should have had that much time just to verify what she communicated to them to say who all now signed on the list prior to the other ones that was against it when we were here last summer. So Miss Henley reached out to me with the same concern, saying that I don't see what they see, but I hear what they say, to say that there's other activities been running in and out the house, and that makes some of the residents uncomfortable. So I haven't even got a chance to confirm that with Ms. Bradley. Is that going on? What's happening in the last time we met since July up to this point for us to be back here again? And that was and that was the disrespect of her intent and not coming back to the council just to have a conversation before we even got here.
Thank you, Councilwoman. You have the dubious distinction of coming before us fairly frequently for group homes, which speaks to the concentration in your ward of such operations.
Yes, and
So you've got this kind of down to a science how you handle it now.
yes, and the group homes are saturated in Ward 4, saturated, and the tent is not the residents are not against the need. They are just against so many group homes that's in Ward 4, that's in their community, that the owners do not live on the street. They do not live in Ward 4, but they practice their group home in Ward 4. And the residents are there every day to witness this. So to give an address where you don't live is uncanny to me. However, if you show more interest in just coming into this community, getting signatures to get what you want to serve, what you want in this ward, and not engaging in no other aspect of any attempt to show that you have concerns, not only for what you want to do, but have consideration, concern of the residents on the street to build a character relationship with the residents so they can be more mindful and more comfortable of what you want to do in this group home. So they have a personal right to speak up, but don't just overlook not only residents, but overlook the council without even coming back and say, I'm coming back again, and I want to have a conversation to be considered by you as I'm reducing from 8 to 5. And could I come back to your community meeting, or even having a meeting on the street with the residents to say, I would like to have a full conversation, even with the ones that's against it. Could I at least have that with you? And that was not done.
Okay,
So I
thank
just
you.
want to just voice my opinion.
Thank you, Councilwoman.
Yes.
Ms. Kukla, do we have any, excuse me one second, do we have any correspondence to add in?
I believe, did we receive an updated email? I believe we received correspondence. from
Right,
the legal team.
is this it?
That might, no, that was from the last
hearing
hearing.
last
Yeah, that's what I thought.
That's June 5th, 2023.
Okay,
Yeah,
so
we
nothing
did-
new.
We did move this into the file,
All right,
the comments from the last.
All right. I'm gonna let you respond.
Yeah, there was no disrespect meant to Councilman Gray. Probably I should take blame for that. My understanding was, and again, I wasn't here the last time, but the opposition was not to whether it was 5 or 8, but that it was in fact a group home. So I thought because of that opposition, and perhaps in hindsight, and listening to her, we should have reached out to her to just talk about the changes. Shelda went out on her own personally and contacted the residents in that neighborhood. We've submitted their signature. She explained to the residents, and she can tell you what she told them about what the kind of people that were going to be there, the 50 to 80-year range, what their issues were, the staffing, that sort of thing, so that they would understand. Again, it seems like the biggest concern here is the way the house is now and the way it's people going in and out. It seems to me that if it was a group home with the staffing that she described, with the kind of people residing in it that she described, it would alleviate a lot of these concerns and be a betterment for the neighborhoods.
Thank you for that, sir. As Councilwoman Gray, as I said, is before us frequently because her ward has a lot of group homes, varying different populations that they're serving, but she's before us quite frequently for these. So she has set up sort of a system with people sort of interacting, having meetings with the community, that sort of thing. So, and you weren't here for the previous hearing, so just FYI for you on that. I'm gonna go.
Can I just follow up with what the attorney said?
Let
about the
me go
betterment?
to Mr. Bay, all right, from City Planning.
Hello, with City Bay, City Planning. So as you can see on this map provided on the screen, where the hand icon is around this highlighted parcel is where the proposed residential facility is being proposed. And these house icons are where current existing residential facilities are. This ring shows you the 1,000-foot buffer that it's in to both of these facilities. And so city planning stands on the same grounds as we did previously. We mainly have this ordinance to not oversaturate neighborhoods, and as we've already heard, this area of Cleveland is very oversaturated with residential facilities, so we would not recommend approval. And I'll also to speak to what's on the agenda, since they're proposing 5 participants, we're only looking at number 1, the 1,000-foot distance.
Madam Chair, one question to Mr. Bay.
Yes, Ms. Wilson, go ahead.
Am I to understand that this map shows there's not 1 but 2 facilities within the 1,000-foot buffer?
Correct, through the chair, Ms. Wilson.
Okay, thank you for confirming that. Further questions?
Good question. Anything else?
Nothing
No?
else?
Ms. Brown, anything?
No.
No? Ms. Roca?
No.
I just said one thing, when the attorney said this is for the betterment for the community. What betterment is for the community when we're moving forward for the betterment of development of housing, of safety, of changing the look of our of Ward 4. The betterment is not to saturate Ward 4 with group homes. The betterment is to give housing for residents and for new homeowners, single homeowners to come and move into these communities. That can also have to be considered will that be a problem of so many group homes in the community? How can we, people would consider to move on these streets and into the community, because we have all these group homes, and I'm not against them. But the point of the matter is moving forward with the betterment of housing in the sense of single-family homes. So when you use the word betterment, what is the cost effective of a betterment of a group homes going to invest into this community of cost effective? How that's going to be the betterment of that community, of that street. So I hear these terms, but every time I sit at these hearings of the betterment and the cost, are these tenants coming from Ward 4? Are these clients coming from Ward 4 that's going to be served in these group homes initially from Ward 4? But are these clients coming from an organization that's going to be the cost and betterment for the owner to get paid through that client services? So from my understanding, nothing has not been discussed on that. Are you getting your clients from the betterment from Ward 4 who have these mental illness, who have these disabilities? No, there's no clients in that house from Ward 4 that's going to be the betterment for them to be a resident in Ward 4. These clients are going through another system to come into the neighborhood. So what's the betterment, the cost of that? Is it serving Ward 4? I can get behind that and have a better understanding. But if that conversation is not had for me to move forward with someone who want to bring the group home into Ward 4, I don't have that understanding to be that supportive when when we see so many of the residents who live in Ward 4 wandering the streets and they don't have a place to stay. And that is a huge issue that I deal with personally, is to find housing for them too. But none of these group homes can take these residents in because they go through another organization to bring other clients in. And it's not like they can walk in and say, can I stay here?
Right,
So
okay, thank you,
just want to say.
Councilwoman. One quick question to Ms. Holzer. Did you have anything that you wanted to add to the conversation?
I don't, thank you.
Okay, great. All right, I'm gonna let you make one last statement, then we're gonna move on. You do not have support of city planning. You do not have support of the council president.
Thank you.
Okay.
I would point out, and I know that it was brought up about the 1,000-foot requirement. From my calculations, the two properties that are in question, two residential facilities, they are not 1,000 feet apart. They are 938.62 feet apart as the crow flies. Walking distance are a little over 1,000 feet. The property in question at 125, as it relates to the Forest Avenue property, as the crow flies at 647 feet, and walking distance is just a little over 1,000 feet. Very similar to the two that are in existence. As it relates to the East 125th with Buckeye Road property, as the crow flies, it's a little over 800 feet, and walking distance again is over 1,000 feet, 0.2 miles. So, it appears that at some point that the planning commission must have approved those two inside 1,000 square feet. I don't know.
Yeah, we don't, I'm gonna say to Mr. Bay, can you testify with assurance that the group homes that are shown on the saturation map are legally operating and have passed approval?
Yeah, so to the chair, I can speak to these two group homes that you see presently existing on the map shown. We get this data from Ohio the full name escapes me right now, the Ohio Mental Disabilities and Addictions Board. And so basically I get the data from them and then I project it onto the map using GIS. So these are currently existing according to their data. And these 1,000-foot buffers are from parcel line to parcel line. I can't speak to whether they were previously approved with city planning's recommendation of approval. Can't speak to that, but I can speak to just replacement and distancing that you see on the net.
Okay,
Madam Chair, Ms. Leonard raised her hand.
thank you. Thank you for that. Ms. Leonard?
Yeah, Shannon Leonard. So the ones that are already existing may have existed prior to the enactment of this ordinance to stop the saturation of the residential facilities.
And can you tell us when that, that ordinance was enacted?
I believe the ordinance was enacted in 2012, but that may, there may be a different date associated with that.
Great, thank you. All right, that concludes our testimony. Do you have anything, one
Yeah,
quick
I
thing
just-
to add?
Yes, I just wanted to finish. So, I mean, obviously, there are a number of these residential homes that they keep getting referred to as saturating the market. I came across this map. I didn't know how to, I printed as best I could. I mean, this reflects these homes that are in the area that apparently have been approved at some point. And it appears that they are very close in proximity. Again, it's not to scale, but
Would you like to submit that?
if I could. I pulled it up on the Cleveland City Planning and Zoning Viewer. I'm sorry, I don't know. But again, I think that, that the concerns that the neighbors have or neighborhood has, I think by having a group home there, it would alleviate a lot of those concerns. Based on what Shelda has advised you about the staffing there, I think it'll be very controlled. The concern that they have people running around and in and out of that's not going to be the case. I think that she has an exemplary record with the state and never, with her license, never been suspended or revoked. She could tell you, she didn't get a chance, but she went and to the residents and explained to them what was going to be going on there, just like she explained to you, the type of facility, the type of residents, the type of staffing. And she went personally herself. She didn't send somebody else. And we submitted that as part of our package to the residents in the neighborhood. And as you can see, the overwhelming majority in that area, and she could have got more. I told her I thought that was enough, but we're not opposed to it. We do have one neighbor apparently that's here and is opposed, and I understand the councilman's position about the oversaturation. But I think in fairness to Shelda, the applicant here, that it should be permitted. I think it would create a hardship on her because that would be the best use of the property. And I think, quite honestly, it would create I don't know if it's a hardship's the right word, but I think it would improve the area with a group home as opposed to a two-family house where concerns have been expressed of people that are, in occupying the premises at this time. So for those reasons, I would ask that consider granting the necessary variance for the 1,000 feet. Again, it's close. It's not right on top of each other. And given that the other two are inside that 1,000 feet, it seems only fairness would dictate allowing the same for the applicant here. Thank you.
Thank you, appreciate it. All right, any further comments from the board? If not, I'll entertain a motion. Ms. Wilson, do you want to take this one, or Ms. Roca?
Madam Chair.
Yes.
I'm not sure it's going to help the conversation, but to the applicant, it is possible for them to request a postponement if they wanted to step back and speak with the community and just for the board's edification. That is another option that the appellant could meet.
Sir, so Ms. Kukla did raise the point that you have that option, keeping in mind that you do not have support of of council or of city planning.
We also have a res judicata
Issue.
situation happening
Right.
here.
So take a moment if you need to consult your client.
The little white noise button.
La, 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 la,
You
la.
have-
Right.
Yeah.
The board speak about the res judicata.
I mean, the position, I guess, is that you haven't met the standard as it relates to the race judicata issue. There's,
I don't know that that's the position of everyone on the board.
but there's no reason we couldn't come back then if that's the case. And if that is the case, then I guess that would be the first thing to get resolved, and so we don't waste your time or Councilman's time.
All right, so to the board, we have taken testimony on the basis of the fact that the change in the number of people from 8 to 5 fulfilled the major change. So are you all in agreement on that?
I am not.
All right, Ms. Roque is not.
I don't
I'm
think
not
that.
either.
All right, okay. All right, Ms. Brown?
To me, they have not established the high bar of res judicata.
Well,
Okay,
I'm not a lawyer, but they've changed the number, but nothing else. I'm not sure. I would want somebody to advise me. I'm not a legal person.
okay,
Yeah, I would also point out that I had to pull up the actual rules that governs res judicata, and it requires a substantial change in circumstances. And so in my mind, going from 8 to 5 would not be substantial. I mean, substantial to me would be something a little more substantial. So, I would love to hear from legal.
That's up to you guys whether it's substantial or not.
We did offer additional information, evidence that was not there the first time around. In terms of the petitions and the other homes and a little bit of her background about her operation and so forth.
Yeah,
That
and
may
thank
not-
you for providing that. And the board did review that as well, but I mean, you're aware of the standard and the heightened standard that applies. And though we appreciate the additional evidence, that evidence has to support a substantial change. And in my mind, the only change that you've offered to the board at this point is that you are still seeking to have a residential facility, but just with fewer people. So I don't know that that's standard of substantial evidence.
Objective standard. It's up to you guys.
Madam Chair, if I could state that they are requesting just one variance at this time, as opposed to the number one is no longer at play here, I guess, because they're requesting 5. So 325.571 has been met as they're only requesting 5.
okay, thanks for that. Ms. Wilson, did you want to make a motion on what you'd like to do at this point?
Oh, sure. So based on the testimony that we have heard, given there has not been a substantial change in circumstances, and even if there has been a substantial change, I've heard testimony that there is a tenant in the unit right now, which would comprise, in my mind, of an alternative economically viable use of the property that wouldn't require variance. Based on that testimony, I would move that we deny calendar number 24-015.
Thank you. Could I have a second, please?
Madam Chair, Board Member Roque, I second.
Thank you, Ms. Rocco. Ms. Kukla, if you'll call the vote, please.
Ms. Holzer,
Yes.
Ms. Brown,
Yes.
Ms. Roca,
Yes.
Ms. Wilson,
Yes.
Ms. Day.
Yes.
Calendar number 24-015 is denied. It'll be ratified next Monday, and we will send you a council letter.
May I ask, is the denial based on res judicata? Or what we're seeking? I mean, it makes a difference.
So I think the way that I saw the motion, it would be based on res judicata. But also if res judicata was considered met, in my mind, the unnecessary hardship standard was not met, given there is another economically viable use.
And that was the motion that we all agreed to. So res judicata was not met, and then the underlying standard of hardship was not met.
Thank you.
And just for your information, Ms. Wilson and Ms. Rocca are both attorneys in addition to.
But we do not practice law.
Right, they do.
As members of the Board of
Right.
Zoning Appeals.
But that is their, to put things in context, that's their frame of reference in addition to our law, our legal from the city.
City.
Okay?
Okay, all right.
So, thank you.
All right, thank you.
All right, I believe we still missed, thank you. Good to see you again, Ms. Councilwoman. Okay. All right.
Sorry, I didn't mean to interrupt you. I just want to make it clear for anyone
No, that's
on
fine.
YouTube and in the room that we do not practice law well.
That is absolutely.
Operating as members of the Board of Zoning Appeals.
We are all about
We have,
transparency and
Very-
ethics.
yes, very stringent standards on things.
Yes. All right. So Councilman Harsh has been patient.
Hello.
Thank you for that.
Good morning.
All right.
Good morning. Ms. Holzer, that takes us to calendar number 24-001 with Councilman Harsh present with us.
Sounds good. Our next case is calendar number 24-001. This is a rehearing for case at 4545 State Road. Keith Edwards Enterprises LLC proposes to erect a second floor addition to a painting contractor business in a C1 local retail business district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are two. Let's see, I'm reading the notes. And I apologize if I butcher anyone's name. Jacinto Delano, the adjacent neighbor who was not able to be present at the hearing, submitted a letter of opposition through email. Many pages were attached but not subsequently read into the record. Parenthetically, they were printed and made part of the file. At the time of the hearing, it was noted that the planning office received a letter of opposition, but the entire packet of information was not explicitly read into the record. Now, the attorney for the neighbor is requesting to have that information fully presented to the board. And with that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holzer.
If you'd like to step forward, gentlemen, you are for this case, correct?
Yes.
Yeah, if you'd like to move. Are you also? Yeah, step forward. Take your place at the table. Let us get everyone situated and then we'll move on. Do we have anyone online for this case?
I'm here, but
Yes, besides you, Councilman. All right.
Hello, Madam Chair, Charles Kennick from Old Brooklyn CDC, 4274 Pearl. I do to the statement.
Charles, we're gonna let Ms. Wilson do the oath, so
Okay,
thanks
perfect.
for being thorough in your name there, that is appreciated. But we're gonna let Ms. Wilson go in her order.
All right,
Perfect, sounds good.
Thank you. I am swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your right hand, reply with I do, state your name, spell your name, and give your address. I'll start with you.
Attorney James Cashman on behalf of Mr. Delano. Last name Kashien, 5241 Broadview Road, Suite 400, Parma, Ohio, 44134.
And do you swear or affirm?
I do.
Thank you. All right.
My name is Jacinto Delano. I live at 3402 Hillcrest Avenue, 44109, Cleveland, Ohio. I live behind 4545 State Road. I am the adjoining neighbor.
Okay, and can you spell your name for us, please?
Giacinto, but I go by Gino.
Okay, and what about your last name? Spell that.
Delano, Dellanno.
Okay, and did I hear you say I do?
I do.
Oh, perfect. Thank you. All right.
My name is Charles Kosinski. That's Kocinski. I'm the tenant at 4545 State Road.
Okay, and do you swear to tell the truth?
I do.
Thank you. Okay, moving now to those of you who are online and wishing to speak in this matter. I'll start with you, Councilman Harsh.
yeah, I do. Chris Harsh, HARSH, Chris KRIS.
Thank you. Thank you.
I do, Charles Kennick, KENNICK, 4274 Pearl Road, 44109.
Thank you. Is there anyone else online wishing to speak in this matter? All right, hearing none, back to you, Madam Chair.
Great, thank you. Ms. Kugler?
So Madam Chair, this case has a long history, In 2023, the applicant applied for a variance and was granted for the identical request. That variance was allowed to expire, and then in January of this year, this board granted a variance to again erect a second floor addition. If you'd like, I could read the testimony that we had at that time into the record. Or I would just state that, as was read in the description, our office received an email at 2:00 on the Friday before the hearing. We did read into the record the email stating that the neighbor was opposed and was able to attend, as well as the attorney was unable to attend. However, we did not read the entire 8 pages that were attached.
All right. We'll loop back to that. Mary?
Madam Chair, members of the board, appellant is requesting a use variance from the requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
All right, thank you. Is it Cashin?
Cashin.
Cashin. Okay.
Cashin.
Cashin.
Yes.
Got it. All right, if you want to
Yeah, if I may first.
make comment.
Ms. Kukla, I actually sent you an email with a Google Drive link that has the original letter. I only have one copy. I don't have color photos that were attached. If you could submit that to the board members, I can, I guess, as reference, who have access to it. It has the letter, additional photos, and some public records.
So this was submitted.
I sent it directly to you today. I could resend it individually.
It was sent today?
So the board hasn't
We
had a
have
chance to.
No, it was, that does not fulfill our requirements for it to be in on time.
Okay.
For us to, our secretary sends out our packet. It's prepped, we receive it at the end of the week.
Okay.
So if you didn't meet the deadline, we don't have it to see it. It hasn't been in our packet.
I understand.
Okay? So,
Yeah, I guess I'll continue. So as the board is aware, our main concern is with the addition of the first issue for this calendar number. Due to, I guess, confusion partially on our end, the letter that was submitted was not read on the record. We apologize for that, so we request a rehearing. And so basically we take issue with the second floor addition, allowing the appellant to operate a contractor business on the property, as we believe is detrimental to the community and contrary to the established zoning code. Our main concern is that the appellant is painting on the property as if it was zoned for a semi-industry district, which actually specifically allows for painting businesses. Our fear is that granting the variance will allow the business to continue to operate as is, as painting on the property, and only exacerbating the problem for Mr. Delano. We're trying to resolve these issues civilly without court intervention. These issues pretty much between the neighbors, Mr. Delano and the appellant, started back in 2018 when new owners purchased the property and the appellant moved in and started running contracting businesses of various names out of the building. What Mr. Delano has experienced since 2018 is a pattern of conduct, or business practices rather, that have been objectively harmful towards him and the community. For example, and Mr. Delano will be providing a statement after me, and he can kind of elaborate on more of his personal experiences. He's experienced numerous occasions where the appellant's business has been painting on the premises of the facility, and or using noxious chemicals that have actually, and fumes that have entered into his home. causing significant health effects to him and his 100-year-old mother that resides with him. For example, most recently on January 23rd, 2024, he experienced a burning odor in his home that caused eye, throat, lung irritation, difficulty breathing, and chest pain for him and his mother. On December 12th, 2023, Mr. O'Donnell actually was walking to a local convenience store and happened to walk past the garage of the original structure where the appellant operates his business and noticed that a ton of cabinets were being painted inside of the facility, and attached to the original letter. I guess I could pass it. It's not color, so I apologize. He actually witnessed an employee painting in the inside of the building.
What's the date of that?
December 12th, 2023. From this angle. If I might present this to the board. I don't
It's
know.
on the screen.
Yeah, it's on the screen.
Okay, thank you.
So we have that.
Yes. So Mr. Delano will testify to this, but he observed the whole facility just covered with cabinets being painted on the premises. And from Mr. Delano's experience, this has been going on over and over again since the appellant moved in. Fortunately, he observed this and it was in plain view from the sidewalk, so he took a photo. From our understanding, there's no fumigation or air filtration system in the appellant's building, which ultimately leads to the fumes and odors entering Mr. Delano's home as he is the neighboring property. We also have to recognize that Mr. Delano resides in a home that's a century home built in 1924. It's not going to be an airtight seal. It's going to be susceptible to neighbors' pollution. He's been dealing with this problem. He's been contacting numerous public agencies and is in the process of trying to resolve these issues. Unfortunately, has not been able to do that. I also do want to point out that this board previously granted this variance and made it a condition that the appellant could not paint on the premise or the property. At that April 24th, 2023 hearing, the appellant was specifically asked and testified that no painting occurred on the property. Ms. Faith and Ms. Kukla specifically asked him that question. In addition, Mr. Delano's other concerns with improper waste disposal from the business. He's experienced the appellant's company employees. Most notably of concern is like drop cloths for painting. He's observed employees just shaking them in the parking lot, and then most notably where this driveway is. It's kind of hard to describe with the property. That is a precise example of just shaking it right in front of Hillcrest Avenue, which we can only assume is paint chips from whatever job or construction site they were working on. And I can only leads us to believe that potentially it could be lead paint as well, or asbestos debris from siding or something like that. It's very alarming. In addition, the appellant's employees have shaken drop cloths into a dumpster that's on the property, but the paint chips or debris is not properly bagged or sealed. It's just thrown into the dumpster, and then on windy days, the lid blows off the dumpster, and then debris accumulates on my client's property. In addition, we assume in conjunction with the appellant's business practice, large amounts of construction debris and other waste accrue on the property and happen to be there for extended periods of time. For example, such as awnings, tires, old windows, paint buckets, batteries, etc. Also do want to point out that the appellant did build a structure, I believe in 2019, as a storage facility to the north of the original building, and it created two alleyways, more or less, I guess I'd describe them as alleyways, in between the buildings, and then the north property, there's an additional alleyway. And of concern is that north property, the grade of the parking lot is such a way that it's only 4 to 5 feet tall. So where if you are on the appellant's property, you can almost climb onto, in the top left picture, left alleyway. There's a low end of the building in the back where it's only 5 feet, so you could easily climb on the debris on the appellant's property and climb onto that northern property, which is kind of concern and definitely an attractive nuisance for children in the neighborhood. That's a welfare concern for the community. As Mr. Donald's experienced, children, run around and do not smart things quite often. In addition, he has concerns for the general maintenance of the exterior of the property, especially along the border between their properties. There's weed, debris, trash that has just accumulated. We do acknowledge that recently, just this past month, that has been largely cleaned up. We appreciate that, but we're concerned that after oversight goes away, it'll just come back, and unfortunately at the detriment of Mr. Delano. In addition, Mr. Delano has experienced appellants, employees of particular concern is this driveway again on the right next to his porch sunroom. Employees have started vehicles and ran the vehicles for extended periods of time, not just 5 minutes, like 30 minutes at a time, on one occasion for about an hour and a half. And again, Mr. Donald resides in a Century home. Exhaust fumes from the vehicle have entered his home and caused breathing problems and acute distress to him and his mother. And Mr. Delano has had to contact the police in regards to this. Unfortunately, tensions between the appellant and Mr. Delano have also increased to the point where Mr. Delano has faced intimidation or harassment from the appellant himself and employees. Most recently, on March 1st, Mr. Delano was talking to a neighbor across the street, and the appellant stormed out and confronted him about being a drug addict or something along those lines, and then it tumbled into a dispute about the property, and simply, we believe essentially the appellant is upset that my client's just exercising his rights as a citizen to protect his investment and try to resolve this civilly. Mr. Delano can certainly comment to attest to that in a little bit more detail. I also do want to point out that now I'm going to kind of dive into the legal argument of the letter. I utilize a less stringent standard, the practical difficulty standard, but this requires the unnecessary hardship standard to grant use variance. For the sake of time, I'll just touch on a couple of the essential points that the appellant has a burden to prove. One of the particular points that the appellant has to prove is that the property cannot be put to any economically viable or appropriate use under its current zoning district. Here, I believe that cannot be met as the business is running as a showroom, and appears to be running business behind it. It's hard to imagine how the addition will is absolutely necessary for him to continue business there. Another point is that the hardship condition was created by the appellant. We're of that position that this was a self-inflicted hardship. Similar to the first point, he's been doing business there for the past couple of years. There's really, from Mr. Delano's perspective, there's no real reason to see how this hardship has only just become apparent now. I guess we want to point out that's not really clear why additional structure needs additional offices and so forth. Based on the January hearing, there was never any testimony regarding the business hiring more employees or more managers to actually occupy the office space that it suggested. Another point, the variance, we're in the position that the variance could affect the community character along with public health, safety, and general welfare. Touched on that previously, but particularly with the character, I want to touch on a little bit here. The main concern is that the appellant's proposing that he's going to establish a showroom, but comparatively to the other small businesses nearby, like the convenience store or like barber shops, that actually invite traffic every day, foot traffic from locals every day into the facility, and you know, those types of small businesses really rely on everyday interactions with the locals to run. It's difficult to see how showroom is similar in that circumstance. That kind of goes along with the, by granting variance, the general spirit and intent of the zoning code. Zoned as is for small businesses that aren't really producing any pollution, or it's not like a giant a Walmart or something like that. It requires extensive parking and it's inviting too much business. You know, whereas that type of business would probably be more infringing upon Mr. Delano as a neighboring property if there's too much business going on there. We believe that it's zoned as is proper for those types of small businesses that deal in small numbers of goods and services. Now,
I don't want to cut you off, Mr.
Yeah.
Kaplan, but we will need you to get to your final points soon.
I understand.
Madam Chair, for the record, the letter that he made, are you reading from the letter that you submitted to us?
Not entirely. There are a lot of points that the legal standards are pretty similar, but
So there's overlap?
to a degree, yes.
Okay. Do you want to read the letter into the record, which was the basis for your request for the rehearing?
We do not have to. I guess I just offer it into the record.
So we have we
We
do
have it.
have a letter from you in our packets dated
Mhm.
January 26, 2024.
Okay.
We were unaware until today that there was a new letter.
There is not.
That's what the confusion that I
Okay.
have.
Okay.
So is the letter that's dated January 26, 2024, it's a substantial letter with all of your points
Mhm.
and pictures, is that the relevant letter, or is there an additional letter?
That is the only letter.
Okay,
My legal analysis was under the less standard in that letter.
okay,
However, the legal standard today requires the more stringent standard.
Okay, okay.
Undue hardship.
Okay.
I believe. Unnecessary hardship standard.
Okay.
Compared to the practical difficulties standard that I referenced in the letter. But a lot of the points are pretty similar, in my opinion.
Okay, so let's just, the letter that we have is the letter. There is no new letter.
Correct.
The points that you have covered are included in the letter that we have.
Yes.
All right. So there is nothing additional then, outside
He's
of what's in
testifying
the
to
letter?
the hardship standard.
He's testifying to the hardship standard.
Yes.
Okay.
And
Is
did you
there-
provide additional photos as well? Like today, when you sent something to the board,
There are additional letters, yes.
or photos, you mean?
Yes, and
Okay.
some public records as well.
Okay, so those are the things we've not received.
Correct.
Okay.
So of course, if the board would like to review those, phone the case.
Right.
I guess I'll just wrap up briefly for everyone.
Sure.
Just in addition to the additional photos that were attached to the original letter, January 26th, some of those are available on he hand selected a couple of photos that we included. Those just kind of establish the pattern, the behaviors that the business has been engaged in over the years.
Previous years.
Yeah, since they essentially moved in.
Okay.
Ultimately, today, we asked this board to deny the variance, or at least consider extensive continuance or time, so that we can confirm that the appellant will actually be in compliance with the zoning, that most particularly no painting or use of any chemicals is occurring. Mr. John ultimately wants a reasonable solution here. Absolutely pro-city, pro-business. We don't want vacant buildings, but if the conduct persists, Mr. Delano will be forced to move, and then they'll fortunately end up with a vacant.
Let me ask you this, and I'm going to address it to you, since you're counsel for the gentleman. Has there been conversation with regard to the complaints to the CDC or to the city council person? You've stated that the police have been contacted on several occasions.
Yes.
But has the council person or the CDC been contacted? Has there been communication about that?
He has had contact with, I think, Cleveland's Division of Air Quality, and I think that's affiliated with the Department of Health. And from my understanding, my talks with Mr. Delano, he has contacted his city councilman, but I'll kind of have to defer to him.
Sure. All right. Sir?
Yes, I've tried to call Councilman Hirsch and he ignored me. He never returned any phone calls. That's why I had to hire an attorney to handle this, because I'm not getting any results from the city of Cleveland, because they say it's so hard to catch the people that are painting, that by the time they come out there, they got everything all disappeared. They take the drop cloths, they hide everything, and they don't find nothing. And if they smell paint, they got a paint warehouse full of paint. They can't tell if they're spray painting or not. But if you would like to hear, I have a written speech. If I could explain to you what happened from the beginning when they first moved in till now, if that would be okay. Do you want to hear my speech?
Sir, how long is it at this point? Does it cover other things? And
Yes.
is it relative to
Yes. Yes.
the current
Maybe
business?
5 minutes.
All right.
My name is Gino Delano. My parents moved to 3402 Hillcrest in 1967 behind 4545 State Road. There was a carpet business at that time. Altogether, there were 3 businesses. And my family had never had a problem with any of the businesses before 2018. The first week Mr. Kaczynski moved in, they got paint chips all over our sidewalk and our tree lawn. When I called the city of Cleveland, they came out and warned them to clean it up, and they never cleaned up all the paint chips. The second week, Mr. Kaczynski had one of his workers spray painting some cabinets,
When was that?
2018.
Okay.
I called the city of Cleveland. 2 inspectors, a man and a woman, came out and went inside and told them to install a painting booth if they want to paint. To this day, there's not a painting booth in the building. Then they put two dumpsters in line with our dining room windows close to our fence. And when they emptied the tarps and the drop cloths right into the dumpsters, all the paint chips blew all over on the ground. None of the workers picked up the paint chips, what could have had lead or oil-based paint chips in them.
And sir, when was that?
2018. I have
2018.
pictures. I have pictures.
Okay.
If you want to see the pictures, I cannot go to the corner store and get a loaf of bread or a gallon of milk if we run out, because I'm in fear of Mr. Kaczynski and his employees swearing at me. It has happened numerous times since Paint Medics moved in 2018. Mr. Kaczynski had a second company called Renovation Systems, where there was trucks burning oil so bad that the blue smoke was everywhere. And when they parked next to our sunroom and let the truck for an hour and a half with nobody in the truck, I called the police, 10/21/2021, 7/9/2022, license plate PJM 8711, PMC 6826, PH 7188, GM Chevy Silver Silverado 2007. And the next day we were both sick.
And this was in 2021 and 2022?
Yes.
All right, go ahead.
September 5th, 2023, workers were shaking the drop cloths so the paint chips and debris by the parking lot on Hillcrest Avenue and the sidewalk where the children walk to school. And also the workers parked their trucks and vans on the sidewalk while they load up so that the residents have to walk in the street. And also the workers parked next to our sunroom, idling their trucks and vans while loading up. I have a journal if the board would like to look at. We have to smell the exhaust fumes in our house constantly. 9/7/2023. I came home from a walk in the park and smelled a strong odor of gasoline in the front of our house by our front steps. 9/8/2023, 7:30 a.m. I watched the workers filling their pressure washers with gasoline right next to our sunroom. So I took pictures. And while I took pictures, one of the workers saw me and started to yell at me and came on our front porch and started banging on our front door. So I called the police. When they showed up, they told me to put up a no trespassing sign and to show them who the worker was that was knocking on our front door. Tuesday, 12/23, 3:21 p.m. I looked under the garage door because I smelled paint, a very strong smell, and I saw over 200 painted panels from the back of the building to the front of the building, and a fan north of the garage door blowing towards our sunroom. The floor was covered with drop cloths loaded with overspray around the panels. So I took a picture with my cell phone and I called Inspector Dave Wagner of Air Quality. Dave came out to talk to me and I showed him the picture and Dave put it on his phone. And when Dave had to go by appointment only, the workers lied and told them that there were only 20 panels that they painted.
What was the date of that?
That was
12/12/2023 at 3:21 p.m.
Okay, all right.
Paint chips on our tree lawn, 12/18/2023. Tuesday, January 2nd, 2024. Mr. Kaczynski had a customer back into the rear parking lot on Hillcrest Avenue with a trailer full of rusty antennas, 50 pieces or more. Saturday, January 13th, 2024, 1 p.m. Smell fumes like a welding torch fume. My mother, 101 years old, and myself had burning throat and a headache. The odor and smell stopped about 3 p.m. I called the city of Cleveland Saturday and Monday. My mother was sick at that time for 5 weeks, and we had to smell that coming into our house until February. She was laying in bed sick. Wednesday, January 16th, 2024, and January 17th, 1:15 PM, I looked at my camera and saw them loading up clean, shiny antennas. They brought in rusty, old, dirty antennas. They loaded them in the building, and then on Wednesday, January 16th and 17th, they were shiny and they looked like they were brand new, and they were loading them up on the pickup truck. February 7th and March 1st, awnings, paint chips, gutters, barbed wire, buckets, and trash up against our fence, lawnmower, ladders, boards with nails, shingles, leaves, old batteries, car battery. Mr. Kaczynski claims that he's going to beautify the city of Cleveland, yet behind the dumpsters, I have to look at trash, leaves, paint chips, garbage bags, and look at a trailer dumpster from our dining room windows on Thanksgiving with trash overflowing and not covered. You're supposed to cover your trailers. Friday, March 8th, 2024 at 11:42, the day after Mr. Kaczynski got his notification appeal, I was talking to Bill, my neighbor across the street from my house, when Mr. Kaczynski came out of the Paint Medics building and lashed out at me and started yelling at me when I told him about the fumes and the paint fumes and the odors. And Mr. Kaczynski told me, that is what I do. That's my business. Then Mr. Kaczynski told me that I was a drug addict and that there were needles all over my front yard. So I told him to show me where the needles were, and he picked up an orange cap and he threw it at me. Bill, the neighbor, was standing right there and saw everything. And I told Mr. Kaczynski that he did not belong near a residential area. And I called the police Monday 11th and made a police report.
What police district are you in?
Second, I'm a former city employee that worked in the Division of Cemeteries as a foreman and a supervisor. And I have never failed a drug test, never had been convicted of drugs. During a physical blood test, the doctors never found drugs in my system, and I don't take pain pills. I worked for the cemeteries for over 25 years. Mayor Justin Bibb said on television that no resident of the city of Cleveland should have to live in an unhealthy or an unsafe environment. And Paint Medics, Mr. Kaczynski, has violated both. And my mother says Mr. Kaczynski has never showed any respect or consideration towards her living next door to his business.
Right. Does that conclude your testimony, sir?
Yes.
All right.
Thank you.
Thank you. All
I
right.
have pictures if you want.
Madam Chair, we do have something partial on the phone.
Right, right.
And I'd like to know if Mr. Harsh would live next door to.
Well, sir, the councilman is on with us. So, Councilman Harsh, do you wish to make a comment at this point, or would you like to hear from Mr. Kaczynski?
I will wait till the end. I am familiar with Mr. Delano's objection to this, and I would like to hear from Mr. Kaczynski first.
Okay. Sir?
Yes, well, let me start from the back and work towards the front of this whole entire conversation. Let me address the last one at the very, very end, because I don't even know, I'm kind of speechless. The situation where my neighbor was talking to the neighbor across the street started where I was in the office. We were fixing something in the back of our shop, our vehicles. As our neighbor was walking by, giving me the bird, I was kind of, like, okay. I went to the back and the door was open, and I hear him talking about me, referring to me as a bitch. I'm like, okay, I don't even know how to take that. And what ended up happening is I'm like, listen, you know, there's something that's gotta give here. We're just good people doing good things. This is very, very irrational. And the whole thing with the accusing of a drug addict, I'm like, listen, there's stuff that blows back over here, just like there's a syringe cap in your yard. And he's like, what syringe cap? So I went over there, picked it up, and I'm like, this is what I'm talking about. And I threw it back in the yard because you know what? It's just kind of childish. It's like kind of abusive at some point. And I really don't know how to even justify stuff that we don't do. We keep the place nice and clean. And those pictures, yeah, there were our guys. You know, what we do is we paint exteriors and interiors of residential and commercial buildings. We don't bring them to the shop to paint them. On this occasion, 200, somebody had cancer. We usually, what we do is when we paint cabinets, if we do, which is probably about, you know, maybe less than 1% of our work. We do them in people's houses or do them in their garages. The lady had cancer. She asked me, can you do them somewhere? Can you do them at your place? I said, sure, no problem. You guys look at those pictures, flip back to those pictures. There might be 15, 20 of doors, you know, that we painted. We had the EPA over there, over our place, numerous times. Every single time they come in, they're like, I don't know what to say. There's nothing in here. We've had multiple people coming in. We get called, we get the police called on us. And this is the scenarios. Like I had my daughter and my niece, you know, my underage, my niece. Hey, Dad, what's that creep in the back taking videos and pictures of me? It looks like sometimes he's in his Fruit of the Loom underwear through the windows. And I'm like, okay, I'm like that's kind of creepy. Maybe people are making that okay nowadays, but I really don't. I have never knocked on our neighbor's door. But my guys get creeped out when you have somebody with a video camera or a picture, you know, with the camera, taking pictures of them while they're working. So one of the guys like, well, I didn't give you permission to be taking videos of me. You went knocked on the door. That's intimidation, asking a question why you're invading our personal space. And that picture with the tarps, those are power washers. They brought them back when they power washed the house to fold them. So they open it up. They fold it up, they clean up, the same thing that we do at people's houses. I mean, this is starting to get ridiculous. We've been accused of pneumonia. We've never used pneumonia to clean nothing. There is no purpose to use, there's no reason to use pneumonia to clean anything.
Yeah, I think you mean ammonia, not pneumonia.
No, because that was referred to as pneumonia. You know?
Okay.
But and you're absolutely correct. You know, it's kind of ridiculous. You know, we work.
Do you use ammonia?
No, we've never used water, you know, paint thinner here and there, but oil-based paint is not legal anymore, so we don't do it. But it's at the houses. We do residential and commercial painting here and there when we bring stuff back. I don't even know what the antennas and all that situation is. I have no idea. It could have been somebody else. We put cables down so people don't park because people park and bump into our building. The pictures with the awnings in there, we give them to poor people. People, like we take them out people's houses and we, you know, put a couple of them, they're gone because we put them on the house. We cleaned up probably about a month ago because as you could see, it was snow everywhere. So then, you know, we cleaned up, but we do that on a regular basis. We have leftover from jobs from when we roof or when we do vinyl siding or something like that. It's starting to get ridiculous. And the building next to us, it's always been there. Kids used to jump up on top of it and go skateboarding. We put a fence, we put barbed wire because the places were getting, you know, broken into. You guys asked us to take it down. We took it down the same day. We took it down. The store, it got robbed. They went through the roof. But we, you know, we complied because we're, we do what you want us to do. At the same time, there's getting to be like, I feel like I'm abused. My guys are, you know, they don't even, they're like hesitant to work in the back because who knows what bizarre behavior is going to come out next yard. We don't paint houses at our building. We go out to the field and do it. And like, as far as the addition goes, we're trying to make a showroom so people could come and see our work, what we do, as far as vinyl siding, roof and windows and all that other stuff. We have, pretty soon, we're gonna have about 30, 40 people working for us. We're running out of space inside of the building, so we're trying to add offices up on top. We keep everything up real nicely. If you go past our place, it's beautiful. everybody's happy, everybody's looking forward to it. The business is around. We let them park in our place across the street, the barber shop, because they're good people. We try to help out. We try to help out other people too. I mean, this is kind of ridiculous. At some point, I consider it abuse. You know, it's like being in an abusive relationship and you're like, oh God, you know, what's gonna happen next? We try not to use the back of the building, and I don't know what we're supposed to do, whether we're supposed to push our vehicles out into the street, push them in the street before we start them up. The guys start them up, they idle for a minute or two. We're conscientious of fuel costs. So it's not like we're gonna make money by keeping them running. They get in the vehicles and drive out to the job sites, and then they come back. And I mean, I don't even know what to say. I mean, this is starting to get, you know, out of hand.
I do have one question, Madam Chair, if I.
Go ahead, Ms. Rogan.
Um,
We'll get to that now.
So we did make a condition to the variance that your business not paint on site.
We did.
We
made 3 conditions.
Well, yes,
Go ahead.
but that's one of them.
Right.
And we have heard now testimony from these gentlemen and also you that there has at least been one instance of some
Exactly.
painting happening on site. So I want to reiterate, that is not supposed to be happening. And so it needs to not happen. So that's a condition of the variance. And when you are doing painting on site, you are violating the variance or what you've been approved to do. And that's an enforcement issue. Now, we are not an enforcement body here. However, that practice is not allowed. So I just wanted to make that very clear to you on the record.
Right, if I could answer
Yes.
that one, we, you know, this was like, we don't, this is just, you know, an instance, and we had the EPA come on, they're like, you're allowed to paint. You're allowed to paint. And, you know, as long as we don't spray stuff in there, there's a booth from somebody else that was in there before in the back. We don't use it because we don't do it. Like this was just one isolated instance, and they've been there probably about 15, 20 times. So every single time they come in, they're like, I don't even know what to say. You know, we apologize for bugging you. We park all our vehicles on the inside.
All the vehicles are parked on the inside?
I mean, yeah.
Of the building?
Yes, probably about, as many as we could fit in there. We're running out of room.
So what we're seeing in front of us then is not currently those look like.
That's during the daytime, when the guys go in and come out and get stuff and.
Because you testified that the vehicular traffic in and out of the site for your employees was going to be in the morning when they arrive for work.
Right.
And in the afternoon when they return from work.
Right.
And that was it.
Right, and and we followed that. That's our estimator's vehicle, that's my truck. I mean, I go in the office and, you know, do my work, you know, so, I mean, yeah, you're right.
So I just want to go over the conditions that were in the variance. The existing barbed wire fence, or the barbed wire on the fence will be removed. That was at the request of city planning.
Yes.
And because of the optics of having barbed wire there. There will be no selling of paint on site. And there will be no painting that will occur on site. And that the use of the building, the downstairs, will be for showroom only. And the addition second floor for offices only.
You're absolutely correct.
That is all true. So what Ms. Roca clarified with you is that if you have any painting on site, that is in violation. Mr. Bay, can you also, I'm interested about the parking situation. The opponent is testifying that it's next to his dining room window. So do we have any information as, I want to reiterate the parking next to windows to clarify that.
Right, you're right. I believe you're speaking to the 10-foot requirement from designated parking spots and first level residential where there's windows or openings.
Correct. So understood or understand that that is another ordinance you must be in compliance with.
Right.
No vehicles within 10 feet
Right.
of a window,
Right.
okay? All right, questions, board?
Madam Chair, I did have a question. I'm
Yes,
sorry to
Ms.
interrupt.
Kukla.
The appellant, just for the record, did the appellant state that he brings back the tarps and awnings and such to dispose in his dumpster? Is that correct? Or the paint?
You can reply, go ahead.
You know what, if there is a house, somebody asks us to remove the awning, I mean, that's like 1 in 500, maybe 500.
Aluminum, are you talking about? or-
Aluminum awnings.
Okay.
They were in that one picture. Those are the only ones we've ever brought back. And we've given some of them to this old lady next to Second District Police, that hers got torn off by ice coming off the roof. I mean, yeah.
So they're not going directly to the scrap or to like
No, it's just people ask.
Habitat for Humanity?
Yeah, people ask us, hey, poor people, hey, can you, because they usually cost about $400 to $600, some of them more. So we take them off and we run into them here and there where we just give them to people just because. I mean, it's kind of nuts.
So, Madam Chair, could the appellant explain how the tarps are cleaned off? Is that?
Right.
Also took place on that?
Let's clarify that process as well.
This was one isolated, but I mean, it happened. It was a one isolated case where where there was cars parked inside of the premises, inside the, I guess, yard where they couldn't. So they just took the tarps and brought them back because they're wet. So they unfolded them, as you see in the pictures. He unfolded it, folded it up, cleaned everything up. I mean, that was it. That was part of the process. I mean, we have to unfold them and whatever, if something falls out of them, we pick it up and we put it in the garbage and.
Do you shop vac them?
Yeah, we have a blower / shop vac. But this is like I mean, we've been there for a long, long time. That's not what we do. We do them at the job sites, at people's houses. We don't bring stuff back, I guess if we're videotaped every single day, 365, days a year, if there's one incident that gets shown or two incidents over the, almost, 8 years we've been there, I'm sure there, before the building was there are other issues of us running into the, into the fence, and I couldn't understand what the attorney was talking about. There's a building over there. We're talking about 8 years ago before the building, us parking in our place close to the fence, which I think we can. And some of the stuff is just ridiculous. I mean, it's just like, unresearched and just,
Okay,
So,
any other questions, Ms. Kukla?
Madam Chair, so I'm not sure if I heard, so the tarps are, they're not cleaned inside the building then? They're dumped into the dumpster, is that right? They're shaken up into the dumpster?
The dumpster is to the left of the building. It's nowhere near anything. There's a 6-foot space. If we dump something into it, it's a dumpster, so we dump it into it. If we do, I mean, once in a blue moon, that's what it's there for, so.
Well, how close is the dumpster to Mr. Delano's home?
Probably about 40, 60 feet or so, because the dumpster is behind my truck over there, and it's a 60-foot building, and and then you have the, so it's probably more than that.
And one more thing, Madam Chair, I did have a question about the ownership. It says Keith Edwards, is the appellant that's speaking now the owner?
It's my son.
Okay, thank you for that.
Anything else, Ms. Kukla?
I think that's it. Appreciate the clarification. For the
Yes, absolutely. All right. Councilman, do you want me to go for questions from the board, or do you want to comment at this point?
I'll just make a brief comment, and then I'm curious how the board feels. It seems that the objection is primarily to the operation and the management of the facility, of the location. I'm wondering if the objection is related to the proposed second edition at all. It seems like the personal operation of the business would be a separate issue from the question about whether or not they should be going forward with the second floor renovation. And I'm not sure that I see those two connecting. So
I
that's
think
just
that,
that's just
I
my.
think that's a good point of clarity, Councilman.
But I'll hold any other comments.
All right. All right, board questions? Ms. Wilson? Oh, Ms. Rucker?
go ahead.
No, I don't.
None? Ms. Brown?
Well, I have not a question, but a comment. It's an observation. I'm not sure that I see the 2 points separate as the councilman, but I certainly hear the complaints being operational in nature. And I think in keeping with what Ms. Roca said, if we say don't paint, don't paint. I mean, it really is up to you to follow the rules. And I think too, in the spirit of being a good neighbor, to have good operations.
If I could answer that.
We're gonna go ask all questions and I'll give you an opportunity to answer.
I'm done.
Miss, are you done?
Yeah.
Okay. Ms. Holzer, anything?
Sorry, I was,
You were on mute.
yeah, I was on mute, just thinking. I'm also curious, I think there was a question over whether or not there had been complaints escalated to Councilman Harsh's office and or to the CDC. I was also curious whether or not the CDC had been receiving any complaints about the business and or its operation.
Should I address that now or wait?
Charles is on.
We have the CDC with us, so, Charles, would you like to speak to this at this point?
Sure, Madam Chair, I can, if you'd like me to.
We'll
Real
let you speak
quickly-
and then we'll go back to Councilman.
Yeah, so I have spoken with Mr. Kaczynski on a few bases around this case that has gone on for the last couple years. I have not spoken with the property owner about the issues or heard from them until late Friday from his counsel. So from our perspective on this issue is, similarly in concurrence to Councilman Harsh, we see sort of the zoning issue and then the sort of civil matter between the two property owners as sort of a separate issue, and we'd be happy to, help find resources to mediate the issue and provide a space, a sort of a third space for them to gather and settle their grievances with each other.
Well, thank you for that offer, sir. So, Councilman, to you.
Yeah, I'll just add, I have not received any complaints about this business from other neighbors in the community. No emails, calls, no concerns expressed. I do recall meeting Mr. Delano a couple of years back. He was outside, and I think that he, if I recall, it was a couple of years ago, but I think he expressed his dismay with the operation at that time. But prior to this request from Mr. Kaczynski, I had not received any complaints from Mr. Delano regarding the business either. Now, since this has come up, I'm fully aware of his concerns. It was in response to this and not predating it.
Thank you. It is certainly on your radar now, I'm sure.
Yeah.
Ms. Roca.
So I just, this is for the appellant, just going back to the variance. My understanding of your testimony of why you experienced a hardship if this variance was not granted is that your employees, you are expanding your staffing to 30 to 40 people. What is it now?
Probably about half of that.
Okay, and you do not have space for those people to work.
Exactly.
And so your request for a variance is to add additional space to the building to have enough office space for your additional staff.
Absolutely.
And your testimony, as I understand it from previous hearing, was that you'd experience a hardship by not having enough, by the board not granting that variance to allow your business to have adequate space for staff.
The board did grant it.
Right.
And we had a hiccup because one of the architects that was working on our case died. I think he might have been employed too, so, he died, so it took us like a couple weeks longer to get all the, all the paperwork and everything in. That's why we had to come back here again, but that was the reason. It wasn't anything that, we planned. It was unfortunate. So our main architect had to find somebody else to do the structural, stuff, and that's exactly what happened. It wasn't anything that we planned, which is life on life's terms.
Okay, thank you. We've heard from you, sir, on your belief why the standard isn't met. So we have those 3 points that you've made as to economic use, hardship, and character. So no need to reiterate that. But is there any additional final words?
Yeah, just briefly, I guess
Please try to be succinct. We're running long,
I understand.
so we have 2 minutes for you to wrap this up.
Right, I guess we'd also request potentially if the board, if they need more time, I guess we'd ask for a postponement to review the additional materials. And or the board is capable of imposing additional conditions to the variance regarding debris on the premise, if it could be stored in the storage building that supposedly was built for additional storage space, still is stated in the letter, and Mr. Delano testified to the waste outside, and as he stated, awnings were outside. I guess we're not sure why that can't be inside of the structure. I guess another comment too. Yeah, I guess just lastly that, some of the practices, if they continue, appear that the property will continue to run as is, as if they were a semi-industry district, painting on the premise, that ultimately, unfortunately, just directly affects Mr. Delano based on proximity of the business. So, thank you.
Okay, are you crafting this?
Oh, Madam Chair.
Yes, Ms. Kukla.
One question about the use, and if, I think Shannon Leonard is on the phone. If she is able to confirm that the use is first permitted in semi-industry, I think that might help with Mr. Harsh's question about the operations.
Okay.
And would be an expansion of that non-conforming use, which does make it more intense, essentially.
Okay.
That is.
Ms. Leonard, are you with us, and can you speak to that?
Yeah, good morning, Shannon Leonard, Interim Chief Zoning Administrator. So generally a contracting business, even if it's the offices, is first permitted in semi-industry. And I believe that's the use variance that's being requested here. Any type of storage of construction materials, I don't think that's on our agenda. And so that shouldn't really be happening at this location.
I would agree with you. So
I'm not sure if I completely understand. I mean, we use our vehicles, our equipment, and that's
Ms. Leonard, are you specifically speaking to like the awnings that sometimes come on site, the cleanup of the tarps, those sorts of issues? Is that what you're specifically noting?
Yeah, tarps is not so much, but any type of the awnings or any of the materials they may be bringing back to take either back to another facility or home or what have you. Any type of storage of that nature generally requires a different type of variance than what is being requested here.
Okay. So that would be like leftover shingles, those sorts of things, supplies of that nature, not stored on site at this location.
You don't have permission to do that. So you would need another variance.
right. Yeah.
That was not in the application.
Right.
Yeah.
Right. I mean, it's, okay, I hear you guys. I mean, yeah, we do a job, we come back, with the leftovers, we take them back to the supplier. Those shingles we use to weigh our vehicles down in the wintertime because they're rear wheel drive.
Understood, because you're using
Right.
pickups, gotta go someplace else.
Yeah.
Well, that's fine, that's fine. I mean, whatever it is, I mean, we comply.
We're here to address the zoning issue.
Right.
Clearly, there's some civil issues going on here as well. the, Mr. Charles from the CDC is welcome to meet with you parties, so that should help. The councilman now has it on the radar, sir. So there will be oversight. Should we approve this, you will have construction going on. You need to make take every opportunity to be a good neighbor to him with regard to that, because there will be debris, there will be paint, there will be things, power tools going on, and things like that, should we approve this again and you go to construction.
And I appreciate it. I mean, we do that everywhere else when we go. when we work
Okay,
on-site work.
so, step up your game on that. All right, anybody else have anything?
I would just be, very careful with your operations, and be aware of what the law says and how your operations are complying with the laws. With that said, I believe we're ready to make a motion. So here we are, we've already, let me make sure, did you have something?
I do have a question. I'm not sure what the motion is.
Right,
We
that's what-
acted already.
We acted already,
And
so
this request was to make
To
sure that the
rehear.
letter, to rehear the case or to hear the letter?
It was to give him an opportunity to present evidence in the letter that he did.
We
not
already
have.
had,
Right,
that wasn't read into the record.
right, but now we have all of that.
Now we have
We
all
do.
of that.
Correct.
The
So-
evidence stands, right?
That's,
Is that what I'm understanding?
So
that's my.
it would be my understanding that you would be affirming the previous decision, but I think you have the ability to modify it at this point as well. I guess that would be a question to Mary. And I think you have the opportunity to also overturn it. It's a rehearing that we are rehearing it technically. All the notices went out to the neighbors, we treated it similarly to rehearing.
Thank you for that clarification. I mean, it's written there, but
Right.
I did not maybe fully comprehend that. I appreciate it.
Okay, who's crafting this one?
I will craft it.
All right.
Based on the testimony that we've heard from all parties as part of this rehearing of calendar number 24-001, I move that we affirm the Board of Zoning Appeals' previous approval of the variances in this calendar number with the conditions that were stated in the previous variance approval.
Do you want me added?
I'm sorry?
Do you want me added?
I do not have anything to add, but if another board member has a friendly amendment, I am certainly open to.
Ms. Wilson, Ms. Brown, Ms. Holzer, anything else you'd like to add as a friendly amendment to that in terms of an additional condition?
I don't think you use zoning to fix operational issues,
don't.
but I am concerned, and I don't know how to phrase this, what Ms. Leonard was saying about storing of materials that are not permitted and weren't in the original request. That would be my only addition, if that's appropriate.
I don't know that it's appropriate because it would have been a variance had we known about it. And was not a variance before us, but I believe that you now know by being here today that doing that would be in violation of the zoning code, and so it can't be done unless you come to us again and get a variance or request a variance from the board.
And it would not be assured.
So I don't know that we can make that a condition. Shannon has her.
Ms. Leonard, you have your hand up?
Oh, she has a comment.
She has a comment. Do we want to read that into the record?
I can. So this is a message from Shannon Leonard. It says, storage of construction materials would require a new permit application and variance.
Great, thank you.
All
Okay,
right, so I agree it's not to be added. Thank
Yes.
you.
Great. All right.
Madam Chair, we could make that a condition as well if we wanted to amend the resolution to state that storage of construction materials is not approved if any appellant has agreed to not conduct such activities.
Okay,
Okay.
great.
Well, yes, that's pretty much what I was saying, so I'm good with
Gets
that.
to your point.
We'll put that in the resolution.
All right.
She-
Okay, and the ordinance, the parking ordinance stands, so that's nothing new. We don't have to put that in there, but you understand that. Okay?
All right, motion
Proceed.
stands. If anyone would like to second.
Could I have a second?
I will second the motion.
Ms. Wilson seconds. Ms. Kukla, call the vote?
Ms. Brown?
Yes.
Ms. Holzer?
Yes.
Ms. Wilson?
Yes.
Ms. Roca?
Yes.
Ms. Day?
Yes.
So calendar number 24-001 is granted conditionally and has been amended, or will be amended when you ratify it next Monday to meet the conditions that were stated in the motion. And we will send the appellants a letter next, Wednesday after we've completed the affirmation. Hearing of the file.
Thank you, everybody.
To the attorney, I would suggest that you get in contact with, the CDC so that you can set up a time.
Community development, correct?
Yes.
Community development, yes.
Brooklyn Community
Yeah,
Development
there's a-
Corporation. Maybe a mediation option for you.
Okay,
Thank you.
Or community relations.
right. Okay, gentlemen,
Thank you.
thank you. Good luck to you all.
Love you all.
Thank you. It's a wonderful day.
You too.
All righty.
Thank you.
That takes care of all of our council people, is that correct?
Correct.
All right.
I really think.
Yeah.
Formal break.
We have a request for a brief break, so we'll take about 1 minute. A little bit longer than that. Liz, could I have 2 more of the things you gave me? Sure. I have to assume that you're of Italian origin?
Yes,
that
my
correct?
father was Italian, but my mother's Bohemian.
Ah, okay. Well, I picked up a little accent because my neighbors across the street are Italian. And the mom only spoke Italian. She would understand English, but
Right.
we had some interesting conversations
Well-
because she only spoke Italian, so.
Well, how did you communicate?
Well, we talked about things that were pretty general, you know,
Cooking?
cooking, gardening, yeah.
Yeah, because my mother, she's still cooking.
Yeah, she made a great biscotti and pizza, so.
Well, we don't eat much pizza. We just eat spaghetti.
Yeah. Well, congratulations to your mom for living to 101. So
I wanted to live to 102.
Good health.
that's excellent. All right,
Thank you all.
gentlemen, thank you for your time. I don't know why I'm not taking a break myself. It's not gonna happen. Priorities.
Oh, we're back on the record. The eclipse is a priority.
All right, everyone back? Except for Mary. All right, moving on. It is warm, isn't it?
So last week I had them turn down the air. It's very loud sometimes.
Yeah.
And I was having trouble hearing. So I can have them turn it up this week, turn it back on this week. So that it'll be
I think
cooler.
it's really hard to regulate the HVAC
Exactly,
when
yeah.
the Mother Nature is being
True.
so variable. All right, Ms. Holzer, we're gonna go to 24-036, please.
Sounds good. Our next case is calendar number 24-036. This is at 1695 Bradford Avenue. Joseph Wagner, owner, proposes to erect a 24-foot by 42-foot, 3-story, 2-family residence with gravel parking space in a D1 2-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. With that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holzer. I am swearing in all who are present for this case. Is there anyone online who wishes to speak in this matter? Okay, I see Ms. Grigonis has raised her hand.
I do, Donna Grigonis, 2406 Professor Avenue, the Community Development Corporation for Tremont West Development. I don't know if the applicant is here.
Yeah.
I think we thought it was postponed.
Okay, do we have Mr. Joseph Wagner present? Doesn't look like we do.
Through the chair, I do not see his name on the participant list. You could, if it's somebody else, you could remind them to unmute or try pressing *6.
Anyone on via regular phone, you can hit *6 to unmute yourself. We're looking for a Joseph Wagner as the appellant for this case. Do we have any communication, Ms. Kirkland?
I don't see anything.
Ms. Notice said she, for some reason, thought it was postponed.
Yeah, Donna, but we haven't had an email from. Voice message, email.
I didn't receive any voice message.
Carrier pigeon.
Check. Not in my folder. I don't know if we've received anything since February 2021. So we'll reach out to the applicant if Ms. Grigonis could stay on the line with us. We'll reach out to the applicant to determine.
Excellent, great.
Communication, or if he didn't receive the link.
Thank you.
Thank you, Ms. Grigonis. Appreciate your patience. All right. We'll move on to calendar number 23-206.
Sounds good. Our next case is calendar number 23-206. I'll wait for the slides to catch up. All right. Nope.
I think I did see it.
All right. Again, next case is calendar number 23-206. This is at 15506 Park Grove Avenue. Kim Barrett proposes to enclose an existing front porch of a single-family residence in an A1 one-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is 1. This case was postponed from December 18th after testimony was taken to allow time for the appellant to research the front yard setback on the street. It was again postponed from February 26th to allow allow time for the appellant to take further measurements. With that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holzer. Do we have anyone online wishing to speak in this matter? Okay, I see the appellant. I will go ahead and swear you in. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your right hand, reply with I do, state your name, spell your name, and give your address.
I do. Kim Barrett, KIMBARRETT, 15506 Park Grove Avenue, Cleveland, Ohio, 44110.
Okay, thank you very much. Is there anyone else wishing to speak in this matter?
Yes, this is Jim Dunphy with Patio Enclosures. 1943 Midway Drive, Twinsburg, Ohio, 44087.
And do you swear or affirm that you are about to tell the truth with your testimony?
I do.
Thank you. Anyone else wishing to speak in this matter? Hearing none, back to you, Madam Chair.
All right. Do you have anything you want to bring us up to date on, Ms. Kukla?
Madam Chair, I don't believe we took testimony last time. There's been no change to the zoning since 1929. The house was constructed according to our Records Administration Office in 1920, as well as the garage. There are no variances on file and nothing of note in the more recent history other than there were alterations, interior, exterior in 2013. So thank you.
Okay. We noted in the agenda is we did hear testimony on this. Just to bring everyone up to speed, this was the front porch enclosure case. And we had the issue with the front yard setback. Refresh our memory on the legal standard, please.
Madam Chair, members of the board, appellant is requesting an area variance from the front yard setback requirement of the zoning code. To obtain the area variance, appellant must prove that denying the request will create practical difficulty not generally shared by other land or building in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Great, thank you. Mr. Dunphy, are you going to be spokesperson again?
I will be happy to, yes.
All right. Go ahead and give a statement as to what you have found since we last saw you.
Outside of what the evidence that was originally proposed at the initial meeting, which was there's a number of other porches on the street that are already enclosed, and that it is our opinion, the homeowner's opinion, that her enclosing her porch would do nothing but improve the property, the view, the value of the property, the function of the property. I did have a conversation with Councilman Polensek with respect to the situation being at hand, that there are a number of other porches already on Mrs. Barrett Street that are closed in, that are the same distance to the street, which would meet the same setback requirements. His comment to me that those homeowners may have gone rogue, if you will, quote unquote, and took it upon themselves not trying to go through the proper channels to achieve the objective of closing in their front porch as Mrs. Barrett has done. He did submit and provide a letter which I had sent last week in support of the BZA approving the variance for Mrs. Barrett so that she could enclose her front porch.
Great, thank you. Ms. Kukla, do we have that letter on file?
Yes, we do, and it's up on the screen
Right,
as well.
okay. Do you want to just summarize what his stance is on this?
Or he's in support of Ms. Barrett's request. She's been trying to improve her property. Have any of their neighbors showed support or opposition to the variance? So the answer to that is no, we haven't received letters either way. Please be advised that I have received no calls or emails opposed to this request. Therefore, I hope that the BZA would grant her variance request. He's been in contact with Ms. Barrett and her contractor, and she is using a top-end certified contractor and going through the right channels to do the project the right way.
Right, and we know that to be true. At least I do. Mr. Bay, do you have anything else you want to add at this point?
Cedar Bay City Planning, I went out to take measurements of this property setback as well as properties within 100 feet as limitation here provides. So basically, I went out and took a measurement of addresses 1502, 15420, 15416 on Park Grove Avenue, and found the average setback of the street to be 36 feet. And enclosing this porch would be pretty much this enclosed porch would then be 29 feet from the property line. So basically, I just took that measurement to make sure that we're in alignment with the adjudication that was ordered. I reached out to the applicant, or to Jim Dumpy, when their case came across previously when it was postponed, to provide the survey, like similarly that we've seen for the past for situations where the front yard setback it comes up on the agenda for a variance, and that was not provided. So the board is limited to what they can do in this instance. It's nothing against the project, it's just a limitation within the code. So if there's been no evidence to provide that for the board to allow the front yard setback variance.
Okay. Questions or comments, board?
I guess, I don't know if Ms. Leonard's on the call, if she has anything to add, other than what I'm hearing is we don't have the authority to grant a variance.
It's the front yard setback issue again. Ms. Leonard, are you with us?
Yes, good morning, Shannon Leonard. That's right, Xavier. I went out and took the measurements, and unfortunately, the board cannot grant a variance. It does not meet the front yard exceptions of the code.
Does this issue go away when the form-based code is deployed?
Yeah, so the form-based code is not in this area at this time, but under the form-based code, yes, there is no, this is one of the only things in the code that this Board of Zoning Appeals cannot grant a front yard setback, one of two, the other being a liner building on an urban form overlay frontage. But yes, in this case, if the form-based code was extended to this neighborhood, there would be exceptions to be able to grant variances to front yard setbacks.
Good question.
Yeah.
All right. Thoughts?
I just want to make sure the appellant understands. It looks like she's raising her hand.
Right. Ms. Barrett?
Yes. I'm really having an issue with my sleep being disrupted by cats jumping on my porch at 3, 4 o'clock in the morning. I can't even, last summer, I couldn't even sit on my porch. I have a severe allergy to cats. I can't put furniture on my porch because the cats are on it. I can't have flowers on my porch. I mean, I can't even eat. My dining room is right off the front porch because I'm hearing cats, jumping on my porch. I'm at my wit's end. I don't know what to do. It's more prudent for me to have my porch enclosed than to go out and purchase another place or to move. I don't know what to do. I can't say these are stray cats because these cats have collars on them. I don't know who these cats belong to. All I know is I'm being disturbed. I'm sleep deprived. I don't know what to do.
All right. Thank you for that personal testimony.
Madam Chair, this probably would be a question for Ms. Leonard. I know it might be splitting hairs, but if the applicant enclosed the porch with all glass, is that still considered a porch enclosure? Or is it still looks like it's open?
Yeah, so the porch, any enclosure into the, into the setback is considered addition to the house. I don't think it would make a difference whether it was enclosed with glass or another material. However, the applicant,
Yeah, go ahead.
the applicant should work with Councilman Polensek. There is that working with city plan, add a map setback to the street so that she could, her or others that want to have an enclosed porch, if that's a demand in this neighborhood, or any infill housing could set closer to the street than what's currently permitted. It's one of those nuances in our code.
So, just so I'm clear, what you're suggesting, Ms. Leonard, is that the appellant speak to Councilman Polensek about having a map setback for this whole area that would potentially permit these types of enclosures on any of the houses in the area.
Yeah, that's
that what-
correct. For the street, they would allow homes that would like to enclose their front porches or extend closer to the right of way than currently permitted. They would be able to do so based on a new map setback. Because that map setback would take precedence over the existing context, essentially.
Got it.
Which we've had to have happen.
Yeah, Ms. Barrett, did you understand that suggestion?
I think so.
Okay,
How about could we have city planning, a planner, talk to the councilman and the owner?
Xavier, is that?
Is that something can happen?
Through the chair, yes, I can relay this information to the neighborhood planner for the area.
Thank
and
you.
Connect them with councilman, this applicant, and see how we can move forward on a next.
Great. Who's the city planner for this?
I believe it's Ariel Washington.
Okay, no, I think that sounds right. Yeah. Okay, cool. So Ms. Barrett, Ms. Brown just made an excellent suggestion, given the fact that Ms. Leonard, who's our senior city planner, has indicated that if your contractor, should he want to be involved, could meet with Councilman Polensek to work on essentially having a unique setback situation for your area so you could move forward. Can you put contact information in the chat? Mr. Bay is going to put contact information to the city planner for your area in the chat. So please capture that information so that you can move forward. Unfortunately, at this point, we can't make exception to the setback without having some changes made to it. Okay?
Okay.
You want to do a motion?
Sure. Madam Chair, based on the testimony we've heard today, which speaks to our limited authority to adjudicate this case, I move that we deny calendar number 23-206.
Second, please.
Second.
Thank you. Ms. Wilson seconds. Ms. Kugler, if you want to call the vote.
Ms. Olzer?
Yes.
Ms. Brown?
Yes.
Ms. Wilson?
Yes.
Ms. Roca?
Yes.
Ms. Biggs?
Yes.
Calendar number 23-206 is denied. We'll ratify this next Monday and we will send the appellant a letter.
Thank you, folks.
Madam Chair, I did receive notification from our staff that we did get an email this morning requesting a postponement from the owner of Bradford. He had a medical emergency and is unable to make it.
Okay. Do we have a date?
So the first week in May.
May 8th? Is that right?
May 6th.
May 6th? All right, calendar number 24-036 has been postponed to May 6th, 2024 at the request of the appellant, Joseph Wagner. Thank you for joining us today, Ms. Gregonis. We'll see you next time.
I think she left. Oh, I guess not.
Okay. All right, last case. Calendar number 24-011.
Our last case of the day is calendar number 24-011. This is at 3742 East 143rd Street. Ian Luke, owner, proposes to change use from gas station to assembly use in a B1 local retail business district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are two. This case was postponed from February 26, 2024. No testimony was taken at that time. It was postponed at the request of the appellant due to a scheduling conflict. And with that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holzer. Is there anyone online wishing to present in this case? Specifically, Mr. Ian Luke, are you present? Oh, there you are. Perfect. Do you swear or affirm that the testimony? Okay, I'll go ahead and swear you in. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your right hand, reply with I do, state your name, spell your name, and give your address.
I do. Name, first name Ian, I-A-N, last name L-U-K-E. The address is 3742 East 143rd, Cleveland, Ohio, 44120.
Okay, thank you. Is there anyone else present wishing to speak in this matter? All right, hearing none, back to you, Madam Chair.
Super, thank you. History of the property, Ms. Kukla?
Thank you, Madam Chair. This property was originally zoned general retail in 1929, and then in 1945, it was placed in local retail business district. In our Records Administration Office, we found that in 1924, a permit was issued to erect a gas station at the site and install gas tanks. There are no variances on file and nothing of note in the more recent history. Thank you.
Super. Legal standard, please.
Madam Chair, members of the board, appellant is requesting a use variance and an area variance from the parking requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in unnecessary hardship particular to the property such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Wonderful, thank you. Mr. Luke, are you going to be speaking? Obviously you are. Sorry, I have a headache.
That's okay.
Go ahead and tell us what you want to do, and if you can target your comments specifically to the variances that you're seeking, that would be awesome.
Okay, and then could I, is there room to like give why and the history of that or no?
Yeah, go
Okay,
ahead.
yeah, so
Yep.
actually I grew up on that street, roughly 6 homes away from that building. I remember the church that used to be there. I used to pass it up all the time. But when I saw that it was on sale, it was an option for me to kind of do something in that neighborhood. Because I moved away in 2016. Actually, my parents had lost the home to the bank. So it was, and I always had it in my heart to do something, you know, in that area. And especially when I came back from the military and I saw that it took a turn for the worse, it was just like, you know, an option for me to do something in that area. So I was able to purchase the building, and I saw it was already zoned for stuff like barbershop, restaurant, and so on. But I wanted to see if I can open it up just income wise to if I was able to rent it And for the size of the building, it would be a small crowd, roughly, you're looking at, if you're doing 40 something, you're pushing it. And then I did that layout that you're looking at right now of the parking lot where they just switched. But so I did an estimate of the actual like parking lot, because there's an extra space to the left, like a whole lot to the left that is currently gravel. And I plan to use that for parking. I estimated if two people were to ride together, it would be more than enough parking per car. And then there's offloading space in the front, like the slide before that showed the parking. There's like an offloading that could hold probably, 4 or 5 cars, if that, but I would usually just set it for like offloading purposes. And then there's also a gravel space to the left of the building, like when you're looking at a front view where there's the 2 white doors to the left of the building, there's also a gravel space there for parking. So it would never be a point to where people, anyone's parking on the streets.
What is your intended use for the building?
Well, the stuff that it's zoned for, which is like barbershop and restaurant, I don't really see myself entertaining a barbershop, but if it sees fit, I named it Tambourine Place, which tamarind is the actual tropical fruit. So I see food involved, but I mean, for now, I would just, what it's not zoned for is to rent it out as an event space. So that is like my hope now to add that to the list of things that it could be used for. There's a photo, I'm not sure. Oh, sorry.
So you're saying it as your intended use is then, you think food service? Is that what you're saying?
No, well, it's already zoned for a restaurant and a barbershop and a few other things. But what it's not zoned for is to host it as an event space. So that's my my intent of now.
Okay, all right, that's kind of where I was going with that.
Right.
So you may use it for a repast facility, a bridal or baby shower facility, small get-togethers of that nature. Is that it?
Exactly.
Will you be serving alcohol?
I noted in when I wrote the thing that if it was, because I've been on the other end of what I want to pursue, which is rent. I've rented for over 12 years from spaces, and I want to adopt a lot of what companies that do the same line of work, where if you are going to be serving alcohol, then either you provide security or we can provide security.
Okay, so that's a yes then.
Correct.
Okay.
So are you gonna pursue a liquor permit then from the?
That's the aim, and that and I mean, I'm not even sure if that how that's gonna go, because when I asked around, I did my homework, a lot of people said that it has to be approved off, because every area has only a certain amount of like a license that's approved.
Right.
So it would present, but I know that there's if no one is serving alcohol, from what I was told, you don't need it. If it's a bring your alcohol, but I'm not sure how true that is.
Yeah. I practice law in this area. It's very complicated. So just make sure familiarize yourself with liquor laws and regulations before you do anything. But if you are going to pursue, my question was answered. You don't know for sure if you're going to try to pursue a liquor permit, but you don't know for sure if you're going to.
If it's going to be approved, yeah. If it is, yeah. If it's possible, yes, I would.
Okay. And then my second question is, do you own the gravel lot where you plan to park cars? Is that part of your same property, all of that area? Looks like you do.
Yes.
Okay.
Correct. Yeah. When I bought it, there's a slide that shows like a breakdown. When I bought it, whoever owned it had already purchased that. It's like not that one. There's like that one. Yep. So the area, the front part to the left where it says 111 feet by 69, they bought that, whoever owned it previously. bought that part of it. So all, that's what I intend to use for parking.
And you intend to keep it as a gravel lot, not to pave it and stripe it and do any of that?
Correct. I mean, if it's possible, I've already looked at the amounts. It is pushing towards like the 20,000 if you were to pave it and get everything done up to code. It's a 20. So for the near future, I would, you know, inexpensively keep it the way it is.
Okay. And then just to to clarify, I think I heard you say that the event space would only be up to 40 people. Is that correct?
Yeah, seating wise, if I did a graph of like the seating, how many tables you can hold, and I think I had like 6 in there. It was like I did a 3D image, but at 6 times 6, that's like 36. If you want, you can probably try to squeeze one more table, but I saw that one right there. If you count the tables to the left, it's you know, it's kind of crammed for space. So I don't really see it being a large event space.
Well, and you've got to allow for staff or other people too.
Correct. Correct. There
Okay,
you go.
what are your proposed hours of operation?
I had it as the typical, like when people hold events, you know, they start as probably early as 5, and if it goes to like 10, 11, I don't see anything or plan to, just because if I have to close it up midnight, I wouldn't have anything past midnight.
Okay. And 5 PM would be the time that the event would start, but would you need time, extra
He's gotta
time?
have morning.
Huh?
He's got to have morning to be able to set up.
Yeah, to set up and things.
Correct. Yeah. So I would leave it as, like I said, the times I've rented from other people where they have it, they give you the keys, and if you wanted to go ahead and decorate, you know, around like the like, you know, a few hours before, I would leave that as an option also.
So the hours would
I
be,
give like 9 to 11.
yeah,
Yeah,
like
like
9
early
AM.
afternoon, yeah, or even, yeah, if they wanted that. I don't know. I'm not sure if I would do morning, but I'm open
So
to
here's the thing, Mr. Luke, so what we're gonna do is we're gonna give you a time window that is probably larger than what you may need, so that you don't end up in a situation where you're violating the hours that we give you.
Hey, I
So,
appreciate it. Thank you.
okay?
9 AM to midnight.
Madam Chair, for clarification about the gravel parking lot.
I think we have a problem there.
Yeah. For parking, you're required to pave and drain
Yeah,
it.
he's gotta be paved and drained.
And today, the appellant is asking, or it is written up as asking for relief from the required parking completely. So I think if the board wanted to legalize the parking on the gravel, we would need some sort of just clarification or an additional code section placed in there from building and housing, I believe. So,
Right.
You know, the board is just looking at whether to waive it entirely or to require parking.
He showed some other parking in the diagram. Was that gravel or concrete?
It's
Where,
all gravel.
It's all gravel.
In the front is not, but and to the side it's, and when I say gravel too, it's hard gravel, but I'm not sure. I couldn't make out. Someone was saying something. Is that recently that they have it where you're unable to do
No,
the gravel parking?
that comes up all the time, so when you said that, that sent off a red flag anyway, so Ms.
Gotcha,
Kugler was
gotcha.
just kind enough to bring it up. So it's gotta be paved and it's gotta be drained, and the draining part is the most important part of it.
Okay.
So that's gonna have to happen.
Okay. If I can say this, so the places that don't have it, did they get it approved? Well, I'm saying that our family, and I have the name of the business too, recently held an event twice at this place on the west side that only had that. So I didn't know if they got approved for theirs, or do you have to get it
Have
approved?
no
or-
idea. We take it on a 1-by-1 basis,
Gotcha. Okay.
okay? And we wanna make sure that you're up to snuff, so you don't have any issues.
Okay.
Okay. Do we have any correspondence from the council person on this?
No, I don't have anything.
Okay. Any other questions? Ms. Wilson? Okay.
Madam Chair, I'll chime in for city planning.
All right, thank you, Mr. Bay.
Saber Day, representing city planning. The main concern we had is just that this, residential district. As you can see here at the bottom side of the photo, there could be some issues, in the future with that, the context of residential to this entertainment use. And, so that's for the one variance to be required, and then we don't typically, approve of, undrained lots.
Yeah, no,
Environmental
that's
concern.
not gonna fly.
That's all I have to say in this case.
Super, thank you. All right, Ms. Kukla, anything else?
I think that's it. To Mr. Bay, did we determine in our internal staff meeting the number of parking spaces? Can you remember? Was it?
It was a 13 minimum for the use that they're proposing.
Thank you.
Okay. Is that the surrounding area?
Yeah, it's the house next door. It's pretty close.
Yeah, so I think we give the hours need to be a little earlier closure.
Well, we also didn't ask the days of the week.
Yeah.
Right, good point. We went back into the parking. Mr. Luke?
Yes.
We have a few more basic questions we usually ask.
Okay.
So, we talked about the parking lot. We sort of went off on that tangent, so we got that sort of cleared up. Let's talk a little bit more, and you've got an occupancy of less than or equal to 40 people. You do not have an alcohol license at the moment. Should you get into a BYOB situation, you're gonna need to have, if there's alcohol being served on site, you're gonna need to supply security.
Correct.
And what days of the week do you intend to operate?
Weekends, from what I'm proposing it to be, I usually, when I think about it, it's probably gonna be mostly weekends. I really don't see anybody, keeping an event like in the middle of the week, like keeping, like a anniversary or whatever, like on a Wednesday or anything. So I would say probably weekends. I'm not sure if anything else that I thought of that would be in between the week, unless it's something that where someone is just keeping like a seminar or something, and they just needed a space to do like a presentation or something like that, and they needed like a in between
Ms. Brown,
the week.
what do you think about him if he does repass? I don't know how often that or when that's gonna be. Your thoughts on that at all?
Well, then it would be earlier.
Yeah.
Times.
But you think every day?
Oh,
I'm just
sure.
I'm trying to, yeah. Okay, I'm getting ahead now.
Yeah.
All right, Mr. Luke, we just had a little sidebar conversation here because we anticipate if you're gonna be like most of the other facilities of this nature, they come before us. The repass business is something that's pretty common. So we're gonna give you a 7-day a week so that you have an opportunity to capture that business. Should you have the opportunity. All right, anything else, board?
Madam Chair, I heard 7 days a week. Did we specify hours? I'm sorry if I missed that.
Ms. Roca is determining that.
Oh, no. It's 9 a.m. to 11 p.m., Ms. Holzer.
Got it.
So, Mr. Luke, that means we're giving you 9 a.m. in the morning again. So, in case you can capture any business meetings or repass business, you're gonna close at 11. That means the building needs to be vacated by that time. Okay.
Perfect.
So we're
You
kind
said
of
by 11?
yeah.
Okay.
Okay. So, because you've got residential in fairly close proximity, and we're kind of going by what is what we find typical with businesses such as yours. Okay.
Understandable. Yeah. Thank you.
All right. Anything else, board? Who wants to do the motion on this? Ms. Wilson, you want to do this?
I can take it if you want.
All right. Ms. Roca's on a roll today.
All right, Madam Chair. We've heard testimony today from the appellant and the city, and I move that we approve calendar number 24-011 for the appellant to operate an event space with occupancy to be determined by building and housing. But space currently allows for approximately 40 people. Proposed hours of operation to be 9 a.m. to 11 p.m., 7 days a week. And that the appellant will follow the code as it relates to any parking. Wait, hold on.
It's got to be paved and dry.
So, Madam Chair, if I could jump in, the board has the authority to relieve him of all the parking that's required. So that in this case, he wouldn't necessarily be required to bring that parking space up to code or the parking lot. Just, you would have to specify that he wouldn't be allowed to park.
Yes, okay, that's what I was trying to do. Okay,
It's not
so.
code conforming.
Okay, so, noting that the appellant cannot park cars in the gravel lot next door to the building without paving the lot and draining the lot, but that this motion is to approve the variances to remove the 13 spaces that are needed. Gosh, that was a mouthful.
Yeah. Do we feel like that's clear?
I don't know.
Yes, well, it's clear to the secretary of the board.
Yeah, okay, all right,
Member Brown, I second.
okay. Did you include liquor in there?
Well, we don't have authority to do that, so that's a different government entity.
All right.
Who other than?
No, but the security.
The security.
That also, I don't feel comfortable doing that because that's up to the liquor control board, not us.
Madam Chair, we can make sure that it's in the testimony, but if it's not in the motion, we can't.
All right,
put it in the-
fine. Okay, moving on. We have a second from Ms. Brown. Anything else? Okay, call the roll, please.
Ms. Holzer,
Yes.
Ms. Wilson,
Yes.
Ms. Brown,
Yes.
Ms. Roca,
Yes.
Ms. Bates.
Yes.
Calendar number 24-011 is granted with the stated conditions to be ratified next Monday, and we will send the appellant's letter. Please feel free to contact our office next Wednesday for further instructions.
Good luck to you, Mr. Luke.
Thank you guys for your time.
You're welcome. Let's case. All right, moving on to old business. Ms.
Oh,
Kukla,
okay.
you want to do Lorraine?
Yes, should we jump in?
Yep, jump in on that.
Okay, so this morning before you, number 4 on your list regarding 14546 Lorraine Avenue. Last week, this board denied the request to establish use as auto and truck repair. The appellants came into our office the business operators came into the office after the hearing, and they expressed that they felt that they were not able to testify because they didn't understand that they were able to testify without a signed authorization letter.
These individuals sitting in the back.
Right, it's the two gentlemen that were in the back. So they had additional testimony that they wished that they were able to put on the record. I mean, they're asking us to hold revocation and open it back up and bring everybody back to the table and allow them to give their presentation.
So they
Okay,
were present and they decided not to testify?
they were present.
And they were sworn in, right?
No, they were not sworn in.
No. I would state one more thing, there's a little bit of a language barrier.
They also came in late. I do recall that as well. I didn't know that I knew based on their trying to speak at the end, I knew they were somehow affiliated with the case, but
Yeah, it was not evident prior to that.
No, it was not. And
Now, the owner, just to refresh your memory, the owner was there and he represented
Correct.
the case. And he really didn't expand on the actual intricacies of the proposed business. But we did, and again, we did have strong opposition from the councilman and city planning there.
So let me just refresh my memory. So are they telling us there are multiple business owners and only one of them was able to speak, but the other two business owners weren't able to speak? Is that the?
Oh,
Probably
yes, there are
tenants.
several different
Right.
addresses and many different, well, several different for sure. They stated that the city rents the space there and they're storing salt. And I think they mentioned a grocery store. But yeah, there are several buildings on the.
There's not a grocery store now. That came up in conversation
Okay.
in response to Councilman Slipe's comment about the development. We also had testimony, I think, from Shannon. Just reiterate, if you would, for us, your testimony about this case on Lorraine. The fact that if, this particular business was not allowed in the previous zoning. And since the zoning changed, I believe you said that it's not allowed now either, right?
Yeah, excuse me, the repair of 18-wheeler semi trucks is not permitted in general retail, which is the existing zoning as of today. And then over the course of since 2021, there has been a rezoning proposal at this location, and this address would be limited retail, so it's also not permitted. That use is first permitted in a semi-industry district. Now, as the secretary had stated, I think there was a language barrier with the applicant and the business operator at this specific address on this large parcel. That's about it.
So what, Madam Chair, I'm hearing is it's not as if we didn't have a business owner here to testify. Someone as part of the business was here and did testify. The law has been changed. And they I think are failing to understand that.
Well, so the application was made before the zoning was changed. So they are entitled to that zoning that was in effect when they applied.
Okay.
So it is.
And that's existing.
That kind of confuses, the testimony about the updated zoning code does confuse the conversation. It proves that there is a trend toward a more restrictive zoning district, but it still doesn't give them, it still doesn't mean that they were reviewed under that they were under the local, is it local retail?
It's general retail currently, and so that use is not permitted currently. I think the testimony around the new zoning was to show that the councilmen and the residents around the area have been working towards changing the overall legacy industrial zoning, but the industrial zoning is not currently on that property.
So the current zoning did not allow the use, but the general retail was closer to the industrial district zoning, right? But the change of the zoning, again, just shows that the community and the council person want the neighborhood to go and they've into that direction. And they've actually enacted zoning and it's gone through all of the process to approve it. It's just, there's like a 40-day waiting period. So it's in that waiting period right now. It's not officially on the map yet. So it kind of confuses things, other than it tells us that the community wants it to go in a different direction, wants the land use of this particular large parcel to go in a different direction, a more restrictive, more neighborhood friendly zoning.
And as to Ms. Roca's question about we had the business owner present, because I specifically questioned him since he was not the name listed as the appellant in the agenda.
Right, he was a representative of the owner.
Right.
And we asked, that's right, we did ask for the articles of incorporation.
Yes.
And we didn't have those for the file, so
Correct.
we were gonna request those if it was going to be.
Right, exactly. So that he was clearly the person that was allowed to represent.
And that was.
So that was challenged.
Their opportunity to say, we are the owners as well. I mean, I understand there's a language barrier here and I'm trying to be sensitive to that as well.
I don't think they're owners. I think they're tenants.
They're
Yeah,
tenants.
right, they were tenants, so it is, I'm sorry to confuse it, but they were the owners of the proposed business. But they're not the property owners.
And I think that they currently do, and Liz, you can remind us, I think that you said that they already have regular motor vehicle repair existing on the property. And I think there was an expansion to the semis. Is that correct?
I think they were trying to reestablish that, no, there was a history that there had been at one time, but I believe it's been vacated. I don't think
Okay.
it was currently operating there.
The-
But yeah,
the-
there's a history of automotive uses there.
Yeah, it was a car lot, it was a Harley Davidson dealership. There was a garage on it, but that had been vacant for a number of years. They've reinstituted a used car lot on the front portion of Lorraine and the entrance into the RTA and post office.
Okay, well, whatever is legally authorized to be at that location that is existing would be grandfathered in under any zoning changes.
So I think that was the automotive garage. Was that correct then?
So there was also a history about, a repair garage being accessory to auto sales parts. And that was a variance that was granted in 1986, if I can remember correctly. So I don't know if testimony was given as to what's been the most recent use.
Okay. So
this is-
Councilman remains opposed.
And this
And-
is really boils down to, in terms of the adjudication, a timing issue and confusion with.
You could argue that too. That's
So they
another-
applied while a zoning review and action was happening,
Right.
but it was not completed.
Right. So they're entitled to the zoning that they were reviewed under, in a way, you know, if they were reviewed under zoning that allowed it and they hadn't gotten their permit yet, they would still be allowed that use.
Then they wouldn't be before the board. If it was zone semi-industry when they applied, then they wouldn't be before the board for a use variance.
It wouldn't have even triggered for them to be here for anything,
That's correct.
right? Right.
Well,
And we
maybe
had a
somebody has to tell them that.
We had a representative from the business here taking testimony. It's just, it was it these two gentlemen that came in?
Yeah, it was.
Yeah.
So maybe this is a question for you, Mary, but as I understand it, and I could be wrong, so please correct me if I'm wrong. If there are multiple parties that are in attendance for an appellant, is there a rule that states that every single person in that party be allowed to testify?
Oh, they're permitted. Oh,
They're permitted to if they request to.
Sure.
But there's no rule that says we, as the Board of Zoning Appeals, must allow every single person to testify that appears on either online or in person for the appellant. If they don't choose to testify or if they don't.
Oh.
Yeah.
I don't think it was, well, I wasn't there, right? So I'm gonna start with that. I have two questions. I think they didn't understand. I wonder, do they have a lease?
A lease? I don't think they submitted one, but I can tell you one thing, they did actually start working on it. They said that they've done a lot, that's why they're kind of fighting harder, because they've done some work on it, so I would assume that they had a lease. They've done some.
I think
interior.
they're in a spot with the owners and the community. And I wonder if they're protected by a lease.
I can go around the file if you would like.
No.
No, I mean,
That's my question.
that's a great point, is that like, we're here to adjudicate zoning. If they've already started things, and they're tenants, not owners, then they did that relying on some
Right.
assertion from somebody that they would be able to do what they are choosing or trying to do.
Yep.
They didn't have the proper zoning for that.
Right,
So that is not a BZA issue.
exactly.
That's an issue between certain parties, and their assurances to each other and contracts law. So, yeah, I mean, I feel, you know, for these folks who were here and didn't provide testimony, but I also don't, know that I believe this warrants a rehearing. That's just where I'm at.
Okay. Ms. Holzer, or Ms. Wilson?
I tend
Comment?
to agree with Ms. Roca.
Okay, all right, we have an agreement on that. Do we need
Ms.
to,
Holzer,
let's call an actual vote on this? Just
well, I think Ms. Holzer just unmuted to say something, maybe.
Okay, Ms. Holzer?
I was just going to concur with Ms. Wilson and Ms. Roca. I don't know if this necessitates a rehearing.
Okay. Ms. Kukla, do we need to do an actual vote, or can you just record comments?
We'll be ratifying it. You received a copy of the resolution. Oh, I see. I'm sorry.
To not rehear?
Yes, we probably should go ahead.
Yeah, I thought we
Okay.
should.
All right,
Okay. Motion, please.
I move that we deny the request for reconsideration and rehearing.
Second, please.
I would second.
Ms. Wilson seconds. Ms. Kukla, call the vote.
Ms. Brown?
I abstain.
Oh, thank you. That makes sense. Ms. Holzer?
Yes.
Ms. Wilson?
Yes.
Ms. Roca?
Yes.
Ms. Bates?
Yes.
A request to rehear calendar number 24-035 is denied. Letter will be sent to the request.
Okay. Great, that leaves us with old business. Number 1, 2, 3, 5, 13, and 14
Without objection.
without objection.
No objection.
No objection.
Great. Okay,
I should probably tell you, since I have everybody's attention, that we'll be doing a virtual hearing on the 8th.
City Hall will be closed for the eclipse.
This is the eclipse. Excited, and I just found out from Ms. Roca that there will be closed streets downtown, so
Yes,
getting applicants down here was a nightmare,
yes.
so.
I would encourage everyone to look at the map that the city put out last week. I think it was the city, yeah, pretty sure it was. It was in either Cranes or the regular Cleveland.com.
I think that there are some excellent organizations that are doing watch parties in different places, so I think that would be much more fun. So, okay, do you have anything else?
No, just the April 1st, if anybody has any absences.
Okay, anyone anticipate that? We've got the agenda went out for that in the packet, right? Yes? Yes. How is that working for everyone?
Great.
Having everything in Dropbox?
I am noting my absence for April 8th.
Okay,
Make sure that is lost.
And I've already sent my absence for the following week, which is,
The 15th?
yeah, the
yes,
15th.
the 15th.
Oh, that's a problem then. I also may be absent for the 15th. I have jury duty.
That will still have a quorum of 3 members.
All right, anyone else have a problem with the 15th? All right.
Aye.
I will have a substitute for me on the 1st, but I will be out the 8th.
Okay, so you'll have a sub. Our usual sub.
No, he's also out. Andrea will be
Andrea will be with us
likely remote, yes.
and likely remote. Okay, and you're out the 8th then?
Is there
Okay,
a sub for that day?
Probably, I doubt it, since City Hall's closed and everybody got the day off.
all right.
I can, like, if there's only 4 cases, if the board doesn't mind me reading the legal standard.
Well, I think that's probably what we're gonna have to do.
Yeah.
Okay, anything else?
And I'll be sure to put those into the Dropbox as well.
Okay, super. Anything else?
No.
All right, we've got the APA conference coming up. Did you work that out yet?
Oh, yeah, and it started on the paper.
I can only come in the afternoon.
Right, I
Yeah.
know. Did you work that out yet? So you can do it?
Yeah, I can.
Cool. All right, good. Everybody else cool with that? The APA conference? It's great. It's good.
I will not be here. I'll be out of the country.
Yeah, don't brag.
All right, I think are we adjourned?
We
Yeah,
are.
yeah.